and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format because of the ongoing pandemic. The panel this morning is Justice Blake, Justice Kinder, and myself, Gabrielle Wolohojian. Although we are conducting court in this format, all the ordinary rules of argument apply, including the fact that each side gets 15 minutes and there's no rebuttal. And with that, I'm going to call the case of Commonwealth versus Jonathan Durat. I hope I've pronounced that correctly. 2019 P 1738. We're ready whenever you are, Attorney Burkholder.
Thank you. Good morning. May it please the court. First of all, I want to apologize to the court for appearing as if I'm in a cave in comparison to others. I have old equipment. I've tried to resolve the issue. I humbly apologize.
It's quite all right.
I know you've read my brief. I know you've read the Commonwealth's brief. This is an interesting case to me because the facts are very clear. The law is very clear. It's a matter of interpretation. So I don't want to belabor my points other than to raise a few. I just want to remind the court of the following. In the jury instruction for open and gross lewdness and lascivious favor, under subsection 2 of the notes, it specifically states the display must be done in a manner to produce alarm or shock and must actually produce alarm or shock that is serious negative emotional experience. I raise that for the following because of the word as a result. And as you hear my argument proceed, you'll know why I'm saying that. Secondly, and I think most importantly in this case, I want to cite Commonwealth v. Ora, which is also within that same note, which states, as a felony, it is thus much more serious offense than a misdemeanor of indecent exposure and consequently requires a substantially more serious and negative impulse as a result of the behavior. So what do we have? It's clear that that's what the requirement is. However, what it means is been subject to interpretation by the courts. Clearly, witnesses are not required to use any special words or express that they experience the negative emotion for a conviction to lie and the fifth element to be satisfied. Courts have used a variety of variations, and both my sister and I have discussed those, whether it be physical reaction, whether it be the words that were used and the like.
Mr. Burkholder, could I interrupt you for a second?
Of course.
I appreciate you saying there's no magic words, if you will, but what, if anything, can we take from her, what I would say is dogged efforts to have him arrested? Does that behavior at all go into the consideration of shock and alarm, or do you think that's a separate and distinct issue?
I think it's frankly the entire issue, and I'll tell you why. And I try to raise this in one sentence in my brief as an introductory, which is I think we have to look at the events in the context in which they occurred. The beginning testimony of the observer was that she lives in a difficult neighborhood. It's subject to violence. It's subject to issues. Secondly, we have to look at the neighborhood itself and the manner in which people are constantly out. They're constantly exposed to what's occurring. I happen to have some familiarity with that neighborhood. It's everything's close. Everything's right there, and there's a lot going on. I say that because of this, because in that neighborhood, you're exposed to a lot from the very beginning. The number of people walking by, the level of intoxication, narcotics usage, etc., that she testified to. So to answer your question, Your Honor, I think that an individual such as the observer here, who frankly is just a woman trying to raise her children in a difficult situation, is protective of them, and that's completely understandable. But to continuously call...
May I ask you a question about this?
Yes.
Are you suggesting that if a person lived in a, let's say, well-to-do, safe neighborhood, the defendant's conduct here would have resulted in shock and alarm, but because the person lives in an already distressing neighborhood, it wouldn't?
To some degree, yes, I am, Your Honor, and it's not a fault of the individual. We have to look at the circumstances, understand, and I know the court does, and I shouldn't say it in that manner. This is a subjective question, so we have to take the individual as we find them. I interestingly had a conversation with my client yesterday about this very situation, and it was that in that neighborhood, you're exposed to a lot of things on a continual basis, and I'm sure that what occurred here was that the defendant annoyed the living bejesus out of her because he continually returned. His level of intoxication, although it wasn't apparent, I'm sure there was some alcohol influence noted in existence. He admitted to drinking some. He was on his way to get more alcohol. How much, I don't know. He's back in the neighborhood on a continual basis. He probably was staying at Pine Street, which is down the street. And as a result, yes, he's going to be there and she's going to be annoyed. And because
Mr.
of that,
Burkholder,
yes.
just to interrupt for a second to get back to Judge Blake's initial question, if the judge believed in this case that the victim called the police 3 times in 2 days thereafter, why wouldn't it be a reasonable inference for him to draw that she was alarmed by what she had experienced?
I don't doubt that she was alarmed. The question is, what was she alarmed of? That's my real issue. The issue was she afraid? Her very first statement that came in her testimony was, she said, I was afraid. I'm scared because I'm a mother with 2 children. She didn't say anything about his exposure. She said he threatened me, and then she admitted that he threatened me later during cross-examination. It appears in the police report. Then she tried to deny that occurred. So I think that really what I'm trying to focus upon here, the court has already picked up on. It's 2 issues. Number one, the level of her reaction is a function of where she was. And unlike some of the other cases that I said in my brief, like Serrano and Tirado, she didn't cover her face. She didn't exclaim. She didn't run away. She didn't say she was physically ill. And if you believe her admission that she told the investigator she stood there for 5 minutes, that's not shock and alarm. That's Kessler. Kessler says if you wait and then you have to at some point make that statement, then it's different. Now in Serrano, for instance, there was a small lapse of period of time, but again, there was a covering of the face. There was some overt action to try to.
Let me add one more layer then to the analysis, which is at the transcript page 19 at line 15, defense counsel asks her, was this incident traumatic to you? And she answers, yes, it is, or it was. Isn't that shock and alarm?
It certainly is, but not for the reasons that the statute requires. Again, it's Kessler.
So you're suggesting that all of her reactions are explainable and understandable in the context of the neighborhood that she lives in and this annoying drunk guy, but has nothing to do with his exposure to her.
No, I didn't say that. I think what it more importantly has to do with in her behavior corroborates that she was afraid. I think she made the statement, or he made a statement to the extent that I'm going to harm you. And that appears in the police report. She denied it, but certainly that statement in of itself would cause the shock and alarm that we're talking about. But for conviction under this statute, it's shock and alarm as a result of the exposure. And that's not the first thing she said when she testified. She said, I was scared. And because he said this, then she talks about it, and she talks about it very matter of fact. When she's testifying, she doesn't say, I was shocked or alarmed. She doesn't say, I was aghast. It made me physically sick. She didn't say any of that. As a matter of fact,
is it a question of fact as to whether and to what degree her reaction was caused by your client's exposure, as opposed to, her neighborhood, his threat to come after her and her children? Is that a question of fact as to what was the cause of her reaction?
it certainly is, Your Honor.
Okay, and so then how is it that we are to get behind the judge's assessment as to the allocation of causation?
In the case that my sister cites, Lopez, Commonwealth v. Lopez, 2020 case, very similar circumstance. If in fact it's a directed verdict, it's a murder case, and the question is whether or not, and there's conflicting evidence with regards to whether or not the individual participated, and the initial reaction of the trial court was, of course, directed verdict shouldn't be denied because of the fact that the conflicting statements, and because of the fact that it says generally it is for the jury to decide whether to credit the testimony of a witness, citing Barbosa. However, the decision goes on to the next page and says, however, in these unique circumstances, it is impossible to reconcile Lawrence's testimony not only with the testimony of each of the other witnesses. So the point I'm trying to make is this. Yes, in a directed verdict, certainly you've got to take the Commonwealth's evidence at its most favorable light. I don't disagree that. But when a situation like this where we have a bench trial and we have a directed verdict denied, and then, and interestingly, the directed verdict was denied on also count 3, threat to commit a crime, but then there was a not guilty finding after trial. There is no reason in my mind that Judge Coyne could not have done the same thing here. I just don't think the evidence rises to the level to satisfy the statute. It may be semantics, but that's our business. We're all in the business of interpreting what these statutes mean. Kessler has done that. Kessler has said as a result, and here that's what we have. I don't disagree that there was some reaction. The reaction that she experienced yes, ma'am.
Can you help explain for me the relationship between this crime and the crime of indecent exposure? Is indecent exposure a lesser included offense?
It is. There's a recent decision that came out of this court. It's named Workman. I'm sure the court's very familiar with it.
So if we were to agree with you here, what is the appropriate remedy?
Well, I gave some thought to that. And I certainly don't have any authority to suggest to the court that there should be a conviction of a lesser included offense. Certainly the requirement, rather than shock and alarm, is simply offensive behavior. So there is some merit to that consideration. However, again, it's as a result of the exposure. And here, my argument is that's not what it is. And it's unfortunate, but no one has had to address this issue as of yet. I did extensive research. I was still doing it this morning, trying to find some disparity between when there is supposed allegations of threats of violence associated with these things. There always is to some degree, but I never found a case where there was an actual threat. And I never found a case where there were 3 or 4 incidents where there was repeated calls. And the calls the next day were clearly pointed out by trial counsel to not have anything to do with any further exposure. So the appropriate remedy, of course, that I'm asking for, and I don't have to repeat, of course, I want the conviction set aside and a verdict of not guilty. Is there some merit to that? The next question that's also not really clear from the Workman decision is the objective element. Should it be in there? Should it not be in there for indecent exposure? And once, if the court finds that it should be in there, which I think in Workman, they cited one case that said it should, or at least there was some indication that it should, I go back to the same question. Objectively, is this an appropriate reaction? You have to understand, in the circumstances, if you believe the testimony from the observer and the admission that she made that she stood there for 5 minutes, that's not shock and alarm. That's not even offense. They were probably bantering back and forth. I don't think that that's unusual at all. And in this particular situation, and finally, she ultimately went inside and called the police. Now, my sister would like to say, well, that's just an interpretation, and a court and the jury or judge could make that. That requires conjecture. That requires facts that we don't know. That requires a time frame that is not set forth in the evidence, and that's asking more than the court, a trial, a bench judge, or a jury can do. That's certainly not permitted. So I welcome any questions that you may have. I think we're all on the same page with regard to the issues and the like. I think it's an interesting case. It's a close case, but I think that the evidence is insufficient to support the conviction.
Thank you. I think we have your argument. Let me see if there are any other questions. No. All right. Thank you very much.
Thank you.
Attorney Lewis?
Good morning, Your Honors. Sarah Lewis on behalf of the Commonwealth. Before I begin, I would just like to acknowledge the trial prosecutor in this case, who, if she is not in first session, is watching over the court's live stream, ADA Allison Portney. We are asking this court to affirm the defendant's conviction for open and gross lewdness. The Commonwealth indeed presented sufficient evidence to prove that the victim was in fact shocked and alarmed here. I would like to begin just by addressing my brother's argument about causation. I think there's 3 points to make here. First, this court, as it knows, must look at the evidence here in the light most favorable to the Commonwealth. And I think that's important when looking at the issues here and at the evidence presented. I think, importantly, I would like to point the court's attention to a few places in the transcript where the testimony, particularly taken in the light most favorable to the Commonwealth, shows a synergistic relationship between the threats and the exposure, such that the victim's reaction here was to those threats and exposure. So first of all, I would just like to point the court's attention to transcript page 21, where and excuse me, I'm looking at another screen as well, but where it's on cross-examination of the victim, where she says, the question is, didn't you tell him that when Mr. Durat pulled out his penis, he sat there and played with it for 5 minutes? Yeah, he was swinging it, winging it in his hands. Question, for 5 minutes? She says, at me and my neighbor, yes, for 5 minutes. And she says, yes, as he was saying, quote, call the police, you'll see what happens. So the testimony here, particularly in the light most favorable to the Commonwealth, is that these threats are happening as this exposure is happening, such that on direct examination on page 15 of the transcript, when the prosecutor asks the victim what was her reaction, and she says, I was scared. The prosecutor asks, what was her reactions to the threats? She says, I was scared. Those threats and the exposure are happening at the same time. And I think that's important. I would also...
Don't we have to live with the way the question was actually phrased at trial? Because the way that question was phrased at trial was, how did you feel when he said that? And what that refers to is the threat.
And I understand your Honor's question, but I think that what's really important is that preceding that testimony, she says the threats are the threats are made. He then takes out, or I think on direct, he then takes out in his penis and does the exposure. Excuse me, yes?
What we have is the way the question was phrased. I mean, it may not be, I mean, there may have needed to be some more questions. And rather than asking us to fill in what the testimony would have been had the questions been asked.
Understood, Your Honor, but I think that the testimony needs to be taken as a whole. So you have that testimony on direct, plus the testimony I read on cross on page 21, as I pointed to, plus the fact that, as Your Honor's pointed out, the victim testifies that this is a traumatic event. So not only is she scared, it's a traumatic event. The officer then responds to the scene and says that, testifies that she seemed upset, bothered a little bit. You have these strong negative reactions, which the case law requires. Plus, what is crucial here is the immediate physical response. The fact that she, as she testified, automatically called the police right away. Not only did she call the police, but I think it's really important, and this is the third point that I wanted to make with respect to causation, what she reported to the police. She didn't just report the threats, she reported the exposure. And not only did she report, and I would point the court's attention to page 24 through 25 of the transcript for that point, what the officer testified as to her report. Then the next day when she calls the police for the first time, on page 30 of the transcript, there's another indication that she reports not only threats, but also the exposure. There wasn't testimony about what she said on the third call, but I would say that it would be in line with those first two reports. And so I think the fact,
Lewis, is it your position then that in the light most favorable, we don't divorce, if you will, the threat from the exposure, that we consider them collectively, and collectively they amount to shock and alarm?
Yes, that the way the testimony came out, I think if you didn't have the threat here, the exposure and the way the testimony came out was that she was scared in response to this exposure as well. They happened synergistically at the same time. But taking out the threat, you have trauma. You have the fact that she's a little bit upset. You have her own testimony that she's scared, plus these 3 phone calls to the police. And I would point the court's attention to several cases, but I think one that's important here is Taranovsky, Commonwealth versus Taranovsky. It's cited in the Commonwealth's brief, 93 Mass Ab Court 399, where the court reiterates the fact that you not only take the witness's words, but other indicia of a negative reaction.
And that's where the woman got the police officer to come off of the boat or something at the Commons.
Yes, and I actually think it's a strong case for the Commonwealth here, particularly if you want to look at the context in which the exposure happens. In that case, the court, in looking at the subjective component of shock or alarm, it says, I'm quoting from the case, but while the NM, the victim, testified that her reaction was based in part on her concern over the impact of the defendant's behavior on the children who were on the esplanade, she also testified that she experienced a little, quote, a little shock herself. And for this reason, there was sufficient evidence to permit the jury to find that the Commonwealth had proved the 5th element. So there you have, again, the context of, picking up, this is another part of my brother's argument, the context in which the exposure happened, and this victim testifying that in that case, she was worried about these children in the area. So, to the extent that is a factor here, and I think you can divorce it from the facts here, I think we have enough, but to the extent that the victim here in this case is worried about her children in her house, and rightfully so, the court in that case, that's permissible, that's okay, but you have more. You have, again, here, the victim's own testimony about her fear, her trauma, her being upset, plus her three calls to the police.
I'm having a little bit of trouble understanding the exercise that you asked us to engage in, which is if we removed the threats from the picture, this evidence would be more than enough with respect to the exposure. Because if we did the opposite, we would say the same. If we remove the exposure, then the evidence would still remain and we would all attach it to the threats. So what does that prove? I don't understand your argument there.
I understand Your Honor's question, and I actually hadn't thought about that, kind of divorcing it. I think what I meant is that the exposure here was enough to produce it, plus the victim's testimony and reaction to it was enough to produce shock or alarm. But right. I guess I would walk it back.
If we have the issue of causation, that it really needs to be as a result of.
Right. And I, sorry, go ahead, Your Honor, go ahead.
Then what I'm trying to figure out was because I understood your argument to be directed to that point, which is, I don't think the defendant is necessarily arguing, although I thought it was at first in this brief, that the quantum of reaction was insufficient to constitute shock and alarm in this case. I don't think he's making that argument today at oral argument. What he's saying is the reaction was not causally linked to the exposure as opposed to other things that are present in the case, such as the threat, her environment, that kind of thing. And so I'm trying to understand how it is, like, maybe you can just tell us what the best evidence is that attaches the victim's reaction to the exposure itself here, and that would help clarify that.
Understood. And I think my understanding of my brother's argument was that the quantum of reaction was not enough, but he did touch on the fact that in his brief, and the Commonwealth did as well, that what if the reaction or the argument that the reaction was just to the threats? So I would say the best evidence here is that, yes, on direct examination, the prosecutor asks, what was your reaction to that, referring to the threats? But in the light most favorable to the Commonwealth, together, taking that testimony together with the testimony on cross-examination, the threats happened synergistically, simultaneously with the exposure. And her reaction, therefore, was to both events in the Commonwealth's view, particularly in the most favorable to the Commonwealth. That's one piece. The second piece, I would say, is that, again, she testified that this was a traumatic event. The officers arrived. She was a little bit upset by it. And then I think most importantly, you take her 3 calls to the police, which is, I think, really important evidence of fear and intimidation. And not just fear and intimidation to the threats, but fear and intimidation to the exposure. During those calls to the police, she reports not just the threats, but also the exposure. So that's how I would line up the evidence. And the reason I just wanted to say, the reason I pointed to fear or fright and intimidation, not fright and intimidation to the threats, but I would point the court's attention to Aura, which my brother referenced, 451 Mass 125, where the court says on page 128, throughout this process of judicial construction, and the court's referring to the statute at issue, we have clarified that the central purpose of Chapter 272, Section 16, as one of preventing fright and intimidation, particularly regarding children. And I just think that's an important quote here, and it's also referenced in the Commonwealth's brief. So that's kind of how I would line up the evidence. I would just say, stepping back in terms of quantum here, legally speaking, to show shock or alarm, mere nervousness, as this court knows, an offense is not enough. You need evidence of a significant emotional negative reaction, such as this fright or intimidation. And then plus, the court has said this plus factor is the immediate response. And we have that plus factor here. Again, a report of the threats and the exposure that the victim was experiencing, or the victim saw. If the court has no further questions, the Commonwealth will rest on its brief, and just conclude by saying that the Commonwealth indeed presented sufficient evidence of shock, or that the victim was in fact shocked and alarmed here, and the judge properly denied the defendant's motion for a required finding of not guilty.
Let me just see if the panel has any other questions. No, thank you very much. Thank you both for your arguments. They've been very helpful to us, and the case is an interesting case.
And we are live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which is being conducted in this format due to the ongoing pandemic. Sitting with me today are Justices Blake, Justices Kinder. My name is Gabrielle Wolohojian. Although we are sitting in this format, all the ordinary rules of argument apply, including that each side gets only 15 minutes to argue with no rebuttal. I'll now call the case of Commonwealth versus DWAYNE Blackman, case number 2020 P0663. We're ready whenever you are, Attorney Murphy.
Thank you, Your Honor and honorable members of the panel. May it please the court, my name is Brian Murphy, and it is my privilege to represent Mr. Blackman in this appeal. This is an appeal from a motion for a new trial where he was seeking to withdraw a guilty plea based on newly discovered evidence. The standard, as the Commonwealth correctly cites in their brief, is that this motion should be granted if it appears that justice may not have been done. The standard of review is the first topic I would like to discuss because we're not in agreement as to what it is. The standard of review in this case is de novo. In this case, the motion for a new trial was heard by a judge other than the plea judge. Judge Friesen heard the plea, and it was Judge Sullivan who heard the motion for a new trial. At that motion for a new trial hearing, there was no evidence presented. There was no witnesses presented. It was relying solely on the record itself, and Judge Sullivan based her decision on the record itself. And
Mr.
as the
Murphy,
SJ,
can I interrupt with a question? I was curious about your argument on the standard of review because I have been unable to find any cases for a motion to withdraw a guilty plea where a de novo review standard was applied. Are there any cases?
as to a plea, I did not find one either. There is the SJC recently opined on this on a very similar situation in Commonwealth v. Frederick Henderson. That came out about 3 weeks ago. So I only have the SJC site, which is 11702. In that case, it was a Rule 30 ineffective claim. And the SJC stated, whereas here, motion judge was not the trial judge and did not conduct an evidentiary hearing, we regard ourselves in as good a position to assess the motion as the trial judge.
That was not a motion to withdraw a plea, correct?
It was not. It was a motion for a new, it was a Rule 30.
So I take it that if we were to decide that a de novo standard of review applied, it would be the first case to do that for a motion to withdraw plea.
I believe that that is the standard that should be applied
All right,
here.
so let's assume that we were going to apply the traditional abusive discretion standard of review.
I'm sorry, I don't understand the question.
Well, we're not in the business of creating new law at the appeals court. So if in every previous case, an abusive discretion standard of review has been used in reviewing the denial of a motion to withdraw a guilty plea, then I think we'll probably do the same. So if we do that, it might help to frame your argument within that standard of review.
I understand that, and I will say just one brief point on that, which is I've listed in my brief a number of cases where virtually without exception, where the motion judge, be it a motion to suppress, a motion to dismiss, or a Rule 30 motion, where the motion judge has no additional evidence before it than the appeals court. The appeals court has invariably applied a de novo standard, that they have said when the trial judge has no information to which we do not have access. This happens in the motion to suppress context, Commonwealth v. Clark, where it's based solely on a video. The appeals court has said when we are in an equally good position, we will apply it on a de novo basis. But understanding that
Mr. Murphy, I don't want to belabor this point, but aren't all those cases involved in situations or cases rather where the strength of the evidence is not at issue? And aren't we always considering, at least to some extent, the strength of the evidence against the defendant in a motion for a new trial?
It's some of those cases that is true. In this case, I don't think that there is any debate about what the evidentiary record is, meaning you are in as good a position as the trial judge to assess the evidence that would be against Mr. Blackman. But based on that, I think I will turn to what is unique about this case is that Mr. Blackman, firstly, it's worth noting that this was an Alford plea. So the Commonwealth spends some time in their brief talking about the importance of a plea colloquy meaning something, that you don't get to lightly take back what you've said. And in this case, it is worth noting that Mr. Blackman consistently and throughout the entire many years that this case was pending and throughout the plea itself, maintained that he had no idea what happened. He knew that he woke up after getting in a very serious car accident. He knew that he had begun the evening in Boston. He knew that he ended the evening on the wrong side of the Massachusetts Turnpike.
Well, he also knew that he drove a car from Fitchburg to Boston without a license.
He did know that.
In order to go to a party for a coworker where alcohol was that was conducted in a bar, that he had something to drink, that he got in his car after that, and that he got onto the pike.
He knew that he had a drink. It's worth noting that his blood alcohol level was 0.14. Someone of his body mass, that would be indicative of somewhere in the area of 7 or 8 drinks taken immediately prior to driving. It's also worth noting that his lack of memory, what is unique here is that the reason he took this plea is because on the day before trial, he's speaking with trial counsel And I'm sorry, the sun came out, so I don't realize my light has been thrown off. I will fix it very briefly. That the day before trial, he realizes that his counsel has told him, you are going to lose. You cannot explain how you found yourself in this position, and there is blood evidence showing that you were intoxicated. He listens to that and says, I don't have another explanation. I can't give you anything. And so based on that, he agrees to take an Alford plea. If he had known then what he knows
And
now,
also, what was his potential exposure, maximum exposure?
I believe it's a maximum of 20 years, but I'm actually not, I would have to double check that. And I know
And I mean, let's take all the charges together.
they could certainly all be stacked for,
And what would have been his maximum exposure?
I would have to go back and look at that. I would expect probably life.
Whatever it was, it's significantly more by
Yes.
multiples of what he received. So we take that, don't we take that into account when assessing what it is that may have motivated him to decide to take a plea?
Absolutely. And I think that that is an excellent point. In this case, when I first met with Mr. Blackman and talked to him about bringing this motion for a new trial, I told him that if it is granted, this case will go to trial again. This is a very serious case where somebody has been killed, that if a motion for a new trial is granted, there is no chance this case does not go forward again. So at the very beginning of this process, he knew that trial is inevitable. There is no outcome if this motion is allowed other than a trial. Meaning the defense that we have, the GHB-based defense, that is the basis of the motion for a new trial, you can know that he genuinely would not have taken the plea if he had known this, because he knows that if this motion is now allowed, it is inevitable and unavoidable that he will go to trial.
Well, but can I ask you about that? You spent a great deal of time in your brief on what you've described as newly discovered evidence. And I'd like you to unpack that a bit, because certainly the time of the plea, he knew that there was GHB in the system. And as I read the doctor's affidavit or the pharmacologist's affidavit and your pleadings, it seems to me that really what you're saying is that there was an alternative interpretation or explanation of the GHB that was in his system. And I can't find a case, and I'm hoping you can help me with this, that says that a different interpretation is tantamount to newly discovered evidence. I'm having trouble putting those concepts together.
So it is, I appreciate the question. It is newly discovered evidence because at the time that he took the plea, his trial counsel had hired Dr. Benjamin, and Dr. Benjamin had opined that the GHB level that he had seen was essentially an error, that there was that it was not something that made sense, and that he could not explain it. It was an error in the testing. A later expert, Dr. McCoy, who I retained, explained that in fact, if he had been drugged at about midnight when he believes he arrived at the club, that the elimination curve would have left the the level that was detectable in his blood at about what it was. And so all of a sudden,
that opinion would be admissible only if there was some evidentiary basis upon which to find that someone put this drug into a drink, into what the defendant claims is the only glass of beer he had.
So 2 points.
So where is that evidence in this record? Because there, the affidavit of counsel is not going to be evidence.
So there are I have two responses to that. The first is Mr. Blackman would testify, and he would say that he remembered only having one drink.
That's right.
That he would never consume these drugs, and that is not something that he would do on a recreational basis. And that the only conclusion he could come to is that somebody drugged him unbeknownst to him. Importantly, his testimony would not be that he didn't then consume more alcohol, because he obviously did based on the test results. It would be that.
Affidavit here from him to all of these things?
There's an affidavit to him to the effect, to the first part of it. I don't continue what the balance of his
Right,
testimony.
so
would be.
we're not going to consider anything that's not in an affidavit.
Well, his affidavit says, I didn't take GHB, and I wouldn't have. So the evidentiary basis for how do we know that he could have been involuntarily drugged?
But you
is
see,
him-
if even if that were credited, are you saying that if that were credited, it would require a finding that someone else put it into his beer?
No, that would be a question for the trier of fact. And when you combine that with the admittedly affidavit from counsel, but there are two other witnesses who were there and says that is a completely plausible explanation.
All right, we don't usually take bystanders' assessments of the evidence into account.
Are you?
They're not jurors. They themselves do not add any percipient testimony as to whether or not any drug got into the drink.
And their statements are hearsay. We don't have affidavits from them. We have your associate's recitation of what these folks allegedly said.
So I'll take your point, Justice Blake, first, which is I had no other choice.
But an affidavit, black letter law, firsthand knowledge.
This could be this. I had no ability to use compulsory process to get their evidence. This could one option here is to remand this for an evidentiary hearing, where I can then use compulsory process.
No, but I don't understand. Even if that helped you, no one's going to be able to give a test, allowed to be tested to testify that something's possible.
It's not that it's just that something is possible. It's that they can describe the setup, which makes Mr. Blackman's testimony more credible. They can describe the fact that the drinks were sitting in an area that people could easily walk by, that this was a crowded bar where drinks were sat down and people turned around and had a discussion. All of that evidence, they can't, of course, testify that he was drugged because they didn't see it, but they can describe the situation, describe that, and that can be combined with Mr. Blackman's testimony about what he intended to do and what were his actions that evening. And when you combine that with his lack of memory, and you combine that with Dr. McCoy's testimony that all of this is consistent with the involuntary ingestion of this drug at midnight, that is a very strong defense. And it is one that Mr. Blackman would have pursued if he'd known it was available.
Now, were there other drugs also in his blood work?
Those were all explainable by treatments he received since arriving at the hospital. And I think that is included in.
I thought there was also the derivative for marijuana.
There may have been a small amount of marijuana as well. Your Honor, that drug obviously remains in the system for well over a month. And there's no indication that he had consumed it that evening. The bulk of the drug test results were explained by he was very badly injured and the treatments he received upon his arrival at the hospital.
Don't we, in the end, Mr. Murphy, on motions like this or issues like this, come back to the strength of the evidence against the defendant? And it seems to me your position would be much stronger if what was found was simply the GHB, but we also have a 0.14, which would give an independent basis for the defendant's guilty plea. So how do we analyze that?
I think you analyze that by relying on Dr. McCoy's report that if he had involuntarily ingested GHB, that this would reduce his ability to make coherent decisions that are consistent with his intentions, and therefore would explain why he would have consumed alcohol in a way that is inconsistent with his general approach to life.
All right, your time is up. I think we have your argument. Let me see if there are any other questions. No, thank you.
Thank you.
Attorney Herron.
Good morning. May it please the court. My name is Donna Marie Herron, Assistant District Attorney representing the Commonwealth. I would also like to recognize the trial attorney, David Polanco, who actually argued this motion below. The motion judge here properly denied the defendant's motion for a new trial, where the record clearly indicates that the defendant knowingly and voluntarily pled guilty to manslaughter by motor vehicle, and where the new expert's alternative interpretation of the toxicology report and hearsay statements from co-workers do not constitute newly discovered evidence. And I ask this court to affirm the judge's order denying the defendant's motion for new trial. As Justice Blake asked, is there any case law regarding this? I would suggest there is case law, Commonwealth v. Lefebvre, L-E-F-A-V-E, 430 Mass at 181. It's cited in my brief. That may not be the exact citation. I apologize. But in that case, the SJC recognized that expert testimony may not constitute newly discovered evidence for the purposes of a motion for new trial, because recent studies would be more credible to expert testimony, or could have, should have been represented, because they recognized that defendants would raise a new trial whenever they could find a credible expert with new research or new evidence to support their claims, when they could have or should have made at trial. So the SJC has recognized that alternative expert testimony would always be available, and therefore there would always be motions for new trials. So I would suggest that, and the Schumann case, which is also cited in the Commonwealth's brief, supports Judge Sullivan's decision that just because on a TV, he was able to obtain an alternative expert testimony about the test results does not constitute newly discovered evidence. I would also like to point out that the report in the toxicology report and all the reports relied upon by his expert were available and were indeed used by trial counsel below, and he used it with an expert.
Attorney Herron, can you the one case that your brother does rely on pretty significantly in his brief is Di Benedetto, and you say it doesn't really apply here. Could you explain why?
Yes, in that case, Your Honor, it was a murder case in which the technology back then only allowed for the crime lab to say it was human blood. And years later, the defendant filed a motion for new trial, which we had DNA technology at that point. And I believe it was the victim's blood that the Commonwealth alleged at trial was on the defendant's sneaker. And the defendant was able to get a DNA profile and exclude the victim as a source of the blood in the sneakers. So in that case, it's a whole new test and a whole new, which I suggest is not a different interpretation of the same underlying test or test results.
But new technology or new science.
Yes, which this court has repeatedly held is newly discovered evidence, which is DNA testing. I would suggest that to provide the defendant no support in his position that the different interpretation of the same test would constitute newly discovered evidence. I'd also like to point out, as the judge was and trial counsel were appropriately concerned with, the evidence in this case that the Commonwealth could establish, which was that the defendant was traveling on the Mass Pike in a high rate of speed, I believe going 80 to 100 miles per hour in the wrong direction. He had a blood alcohol level of 0.14. And both the defendant's expert's opinion and the toxicology reports, there was THC in his system. And he crashed into the victim's car, causing the car to engulf in flames and her to die in that manner. I would suggest that the counsel was rightly concerned about the facts in this case and being able to establish notably that the defendant did not voluntarily ingest the GHB. And I believe weighed against these facts, the defendant hasn't established that the low levels of GHB in his system would have been a determinative effect on the outcome. And I would suggest that this court should affirm the order denying the defendant's motion for new trial. If there is no other questions, the Commonwealth will rest on its brief.
Let me just see. I don't see any. We appreciate both of your arguments. They've been helpful to us in this interesting case, and thank you both. And with that, the
Thank
case.
you, Your Honor.
With that.
We are going live. And we are on the record.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court, which is being conducted in this format because of the ongoing pandemic. Although we are conducting the argument in this way, the ordinary rules of argument apply as though we were in our real courtroom, including that each side gets 15 minutes to argue with no rebuttal. And with that, I'm going to call the case of Commonwealth versus Luis Polanco-Arias, case number 2019 P 1073. Attorney Peterson, we're ready whenever you are.
May it please the court. Good morning, Your Honors. My name is Jennifer Peterson, and I'm here today on behalf of the defendant appellant Luis Polanco-Arias. As I'm sure Your Honors are aware, Mr. Polanco-Arias raised 3 different arguments in his brief. And if I may, I'd like to begin with the third argument, the separate and distinct acts argument.
Before you go there, do you agree that none of these that we're reviewing all 3 claims for substantial risk?
Yes, Your Honor, I do.
Okay, thank you.
With respect to the third argument, the separate and distinct acts argument. As I'm sure your honors are aware, Mr. Polanco-Arias was convicted of 3 assaultive crimes. The first being strangulation, the second an assault and battery with serious bodily injury to the eyes, the third an assault and battery involving a strike to the face, a fourth a slap to the hip, and the fifth a strike to the shoulder. Counts 2 and 3, both of them involved strikes to the face, one involving the substantial bodily injury to the eyes and one just a strike to the face.
They are different crimes, however, are they not?
Yes, Your Honor, they are different crimes. However, they were both, these both arose out of the same set of operative facts involving the same victim and the same evening. So they all arose out of the same incident. And
But because one involved the separate element of the victim being a household member, do you agree that they could not be duplicative as a matter of law?
as a matter of law, I believe that given the nature of the crimes, that only Mr. Polanco-Arias only could have been convicted of one of the crimes. So if it was involving, the jury needed to find separate and distinct acts that formed the basis for both of those 2 crimes. So, and that's what Mr. Polanco-Arias argues, is that
I'm sorry to interrupt you, but if one is not a lesser included offense of the other, then why is it that the jury would be required to find that the 2 convictions rested on different acts?
I would suggest that the assault and battery on a household member is a lesser included offense of the serious bodily injury crime.
But they each require an element of proof that the other crime doesn't have.
Yes. Yes.
So how can one be a lesser included offense of the other?
I would suggest that one is her status as a household member, and that element is consistent across both of those crimes. So that has to do with her status as a household member.
Well, her status is the same, but the charges are different. One doesn't require that element, correct?
Yes, they have the one separate element, but I would suggest it would still constitute a duplicative conviction, given that they arose out of the same incident here.
But if you look at the verdict slip, so Appendix 29 and Appendix 30, there's aggravated assault and battery causing serious bodily injury to the eyes, and then there's assault and battery on a household member, to wit, strike in the face. So in addition to the household member status, the first conviction also requires serious bodily injury. That is an element of that offense. That is not an element of the strike to the face, right?
Yes.
And so if I were to punch someone in the nose and let's say in the ear, right? Without serious bodily injury, no household member, are you saying that I can only be convicted one time?
No,
because it's all in the head?
No, because I think the question is whether or not what jurors understood the crime to be. And so it's not that the Commonwealth couldn't have obtained 2 separate convictions here. It's whether the jurors were confused as to the operative facts upon which their verdict were based, and whether or not they unanimously agreed. And because the judge here didn't instruct them that they must agree on the same set of facts, there's a question as to whether or not they agreed that certain facts applied to the hit to the eyes, the substantial, bodily injury, and certain facts applied to another strike to the face. And
so you don't quibble with the actual instruction as to each of the indictments?
Yes, regardless of whether or not the Commonwealth presented sufficient facts to support 5 separate convictions, it's unclear what facts the jurors relied upon
But the judge properly instructed, at least as to the assault and battery, substantial bodily injury, and assault and battery household member. But you say he should have sua sponte, or she, excuse me, Justice Tutman, should have sua sponte instructed on separate and distinct acts.
Yes, because I think that the judge should have informed the jurors that they needed to find separate and distinct acts for both of those separate crimes. Not that the problem here was the instruction, not the proof. Had the
Why does the judge need to give that instruction if the two crimes can rest on a single act?
Excuse me, Your Honor?
Why would the judge be required to give that instruction if the two crimes can rest on a single act?
Well, I think here there's a question about whether or not what the act in particular was. It's unclear whether it was a strike to the face, a strike to the or a strike to the eyes in particular.
But didn't the judge take cautionary steps in listing on each verdict form, not only what the charge was, but a shorthand version of what the alleged conduct was?
Yes, she did, Your Honor. But in particular, the words for the assault and battery with substantial bodily injury said causing serious bodily injury to the eyes, and the verdict slip with respect to the assault and battery on a household member simply said, to wit, a strike in the face. So
and why wouldn't that adequately allow the jury to differentiate between the conduct alleged in each of those crimes?
It allowed the jury to distinguish among the three separate assault and batteries on a household member, but not to distinguish between counts 2 and 3, which involved the hitting in the eyes, and count 3, the hitting in the face. So if Your Honors have
And you're saying that I assume you're saying that only because the eyes are on the face?
Yes, Your Honor. Yes, Your Honor.
Right.
And with respect to the opening statement, Your Honor, the Mr. Polanco-Arias argues that the Commonwealth, the prosecutor in this case, appealed to the sympathies of the jury, and instead of providing the proverbial roadmap with respect to giving jurors a presentation about what to expect with the testimony, that the prosecutor intended to instead inflame jurors to get the jurors to turn them against Mr. Polario at the very outset. And with
Ms. Peterson, granted that the opening statement may have been more dramatic than some, but was there anything that was stated in the opening statement that was not borne out by the evidence at trial?
Well, I would suggest, Your Honors, that it's not necessarily a question of whether or not it's borne out, but rather whether it's a question of attempting to use the power the government has to suggest that Mr. Polanco-Arias is a bad person, that the facts are dramatic. They are the ones that are setting the stage here. And the prosecutor focused on the raw pain that was felt, the hurt, how he was trying to control the narrative. Instead of saying, you know, the testimony is going to show that she was injured, that they called the police, that they were at a nightclub, she used provocative emotional language. And this is the first exposure jurors have to the case, so it sets the tone for the case. And she also gave her opinion saying, you know, he wanted to punish her, and that's what he did. So there was a lot of that sort of personal opinion, which is
But
also
his defense was identity, wasn't it? It wasn't him.
Well, there was a lot of confusion regarding what happened that night, and she gave different testimony depending on whether it was to the police officers.
But did she ever say it wasn't him?
No, she was consistent that it was him. Her identification that it was him didn't waver.
How are we to assess, even if we were to accept that aspects of the opening were improper, how are we to assess whether there was a substantial risk of a miscarriage of justice resulting from them without, and I may have missed this in the record, but I didn't see the photographs that were introduced as exhibits, which, you know, were a large feature of the evidence at trial. Are those in our record appendix? Are those in our record on appeal?
No, Your Honor, I don't believe I included photographs in mine, or in the Commonwealth, I don't believe did either.
So how are we going to evaluate what the impact may have been from any improper aspects of the opening unless we do it against the strength of the evidence? And if that's not just the testimony. I mean, we consider everything in substantial risk. We consider the strength of the evidence. We consider the theories of at trial, which, as Justice Blake noted, the defense was identity. It really didn't have to do with, you know, that this didn't happen, that she didn't suffer these grievous injuries, et cetera, et cetera. How are we going to do that without a complete record?
I would suggest that, as a preliminary matter, I'd be happy to get the court copies of the photographs if the court would like me to submit them for its consideration of this particular argument. But to consider everything, the testimony itself has what her and there are also medical records, although I don't believe those were included in the record appendices either. But she gave testimony, and the testimony in essence was that she couldn't open her eyes for about a week. So she had a black and swollen eyes. There was nothing to suggest that she had any permanent, I believe, no permanent injury or anything of the sort to her eyes. And I would suggest that in general, this is per se improper opening statement. And similar liberties were taken in the closing argument as well. The attempt to inflame the juror and to essentially rest its case on the fact that the victim suffered injuries. And the question really isn't whether or not she suffered injuries per se. The question is whether or not the Commonwealth presented all of the elements, you know, that it's required to present in order to prove Mr. Polanco guilty beyond a reasonable doubt of all of these separate crimes. And to allow the Commonwealth to simply try to evoke sympathy for what happened to this woman, to suggest that, you know, that he was just trying to teach her a lesson, he was controlling, he was manipulative. Those things aren't a part of the record. Whether or not, you know, she sustained injuries is one thing, but whether or not he was controlling, whether or not he was jealous, whether or not he was, you know, enraged, those are not things that even could be said to be proven. And those are things that the Commonwealth suggested in its opening statement, as well as in its closing argument. Ms. Jimenez didn't testify that this was her worst nightmare. She, you know, and in closing argument, the prosecutor specifically said this is criminal. He caused her, you know, his jealousy and anger and the violence and pain that he caused is a complete picture, and it's criminal. And he said that, you know, that her body is a canvas for his anger and her jealousy. And it can't be said that that's appropriate argument, regardless of whether or not the photographs or anything else can show injuries to her. So with that, Your Honors, I would respectfully request that you reverse Mr. Polanco-Arias's conviction and send this matter back for a retrial or resentencing.
Thank you very much. We have
Thank
your
you, Your
argument.
Honors.
Attorney O'Sullivan.
Good morning. May it please the court. David O'Sullivan for the Commonwealth. I'll track the order of my sister with respect to the arguments and start with the third argument, and that is the one for duplicative convictions. Counts 2 and 3, of course, charge separate crimes, each of which carries an element that the other lacks. And as our cases make clear, where each crime carries an element the other lacks, the legislature is deemed to have authorized punishment for both crimes, even where the crimes arise from the identical conduct. So there was no need for the judge to give a separate and distinct acts instruction in this case. Of course, one wasn't requested, but even if one was, there would be no error in declining to give it, and there's certainly no substantial risk of a miscarriage of justice in failing to do so, particularly where the evidence was of multiple blows to the head, which each constitute separate batteries. So there were enough to go around essentially for both those crimes, even if that is a separate and distinct instruction were required on this.
But how do we know that the strike in the face isn't the same strike to the eyes?
We don't, Your Honor, and we definitely don't. But the law in this area is clear that the same act can constitute two crimes, where each of the crimes carries an element the other lacks. But yeah, I would agree on the evidence and on the instructions. The jury could base both convictions on the identical punch to the head that either damaged her eyes, causing serious bodily injury, or constituted the punch to the face that was the ABH, the basis for the assault and battery on a household member conviction. Now, with respect to the opening argument, of course, the proper function of our opening argument is to outline in a general way the evidence that the prosecutor in good faith expects to be able to introduce in the case and provide a fair roadmap of what the evidence would produce. And as in the context of a closing argument, there is a difference between a dramatic description designed to appeal to emotions and one that reflects the evidence in the case. And it is not the fault of the prosecutor where the particular evidence in the case is particularly graphic and brutal, there was no dispute from the start that the victim suffered a brutal beating in the case.
Sure, but and even in cases where there's horrific evidence, we still have the rules of proper argument, both in opening and closing. And at least here with respect to the opening, this opening didn't really follow, in some respects, in parts it did, the customary formulations of setting out simply what the anticipated evidence was going to be, but did seem to verge into argument.
Well,
so even though there's horrific evidence, we still don't allow argument in opening statements. That's why they're called opening statements, not opening arguments instead of closing arguments.
Well, that's certainly true, Your Honor. But I would note that there's it's obviously permissible based on the cases that we cite in our brief for the prosecutor in opening to advert to evidence that they would prove by inference. And it's also, and motive is one of the key things that you need to prove by inference. So there's an uncertain line between, on the one hand, permissibly adverting to evidence you expect to prove by way of inference in the opening and argument in the opening. But where I would say that where the function of the opening is to provide a roadmap, and the function of the closing is to provide, to marshal the evidence and to sort of bring it all together. The fact that there are repeated themes in the opening and closing is not only doesn't make out a claim, it's not surprising at all. I mean, we would expect people to say, this is what I intend to prove, and then to show at the end, this is what I did prove. So I wouldn't say that, mere repetition of themes in in the closing, in the opening, I think that is to be expected given the functions there. And here where the references to controlling the narrative, the prosecutor's theory of the case was that in his prior threesome trysts between the victim and he and a third person, the defendant was generally in control of those, chose the person, initiated the conduct. And with respect to what occurred in the bathroom at the Prospect Street after hours party, the defendant was not in control of that. And he attempted to regain control by propositioning a threesome after that occurred, after she told him that. And when she refused, that's what triggered his anger, and his anger was based on the lack of control. I would say that when the prosecutor adverts to that in her opening, she is permissibly talking about an inference that she expects to be able to prove about his motive. And so I think it's permissible for her to have done so, as in the context of closing arguments, enthusiastic rhetoric, strong advocacy, and excusable hyperbole are permissible.
Mr. O'Sullivan, one question in opening that sort of stuck out to me was the rhetorical question of what does Officer Aguirre have to gain by coming in here to testify? In other circumstances, we have held that similar questions cross the line. Why didn't that one?
Your Honor, that was in the closing, and yes. So the Officer Aguirre, there was a reference in the closing to what does Officer Aguirre have to gain by coming in here and testifying as he did, and the testimony that was being referenced was, of course, at the scene, Miss Ayala put on speakerphone the defendant. She identified his voice, and he admitted to the beating and said he needs to, the reason for it, that is, that she's a lesbian, and I got to keep eyes on her. So that's.
Sorry.
I'm sorry. Go ahead, Your Honor.
I had a concern about a statement in the closing that appears between page 55 and 56, where the prosecutor says the prosecutor poses a hypothetical question to herself, and then she says, "Of course he did this to her."
Right. And I'll finish my answer to Justice Kinder's question after, or I could do whichever you prefer first.
Finish Justice Kinder's question first, please.
So it generally, right, it may be problematic for someone to, question whether someone has a motive to lie. But after a person's credibility is attacked, and the victim's credibility was attacked in the course of the defense closing by suggesting that she had a motive to falsely accuse him of this beating. And the motive arose from the fact of his infidelity, his lack of respect toward her. And so where corroborative evidence came from a person with no such motive, it is absolutely permissible for a prosecutor to point that out. And that's what occurred in that instance. Now, with respect to Justice Wolohojian's question, which concerned, I'm sorry, was there the rhetorical question of?
There was a rhetorical question and then a statement by the prosecutor that says, listen to that 911 call and ask yourselves, the woman who you hear crying and in pain, how would she have the wherewithal to say that the defendant did this if he didn't do it? That's the first question. And then the prosecutor says, of course he did this to her.
Okay. Well, so with respect to the first part, I think the prosecutor could permissibly refer to her.
I'm not so concerned about the first question. Okay. I think ask the jury to make an assessment of the witness's demeanor from the witness's demeanor. It's the statement by the prosecutor giving the prosecutor's opinion on the factual question, the question that was before the jury.
I think that those types of statements have to be considered in context. And in context, I would not say that she was expressing a personal belief in the credibility of the witness, just as in Kumaris, which is cited in the Commonwealth's brief, the statement, "he told you the truth," was not in context a statement of personal belief in the victim's credibility. Rather, it was a proper adverting to evidence of demeanor that was in the 911 tape and arguing that it supported the victim's credibility, specifically her credibility with respect to the 911 call's identification of the defendant as the perpetrator, which was the issue in the case, as Justice Blake, I think, pointed out in her questioning of my sister. Now, with respect to the closing argument, there was a reference to a nightmare, and this was a nightmare for the victim. And I do think that was not only an accurate metaphor, and I am probably remiss for not including in the record appendix or a supplemental record appendix the photographs in the case, and I apologize to the court. I'm happy to either have all the exhibits set up and to facilitate that, or to submit copies, as my sister has also offered to do. But again, the fact that these obviously and all the evidence in the case obviously supported the idea that she had been through a nightmare. And we identify in our brief 4 cases in which nightmare is referenced. 2 fall on the side of enthusiastic rhetoric that is permitted in a closing argument, and 2 or 3 fall outside the permissible bounds. And I would say this is much closer to the 2 that are identified in our brief that were not error. And particularly the Hartford case references the defendant as being, quote, every person's worst nightmare. I would submit that that is way more objectionable than what happened here, insofar as it sort of disparages the sinner as opposed to the sin. Still, the court found in that case that was enthusiastic rhetoric, that was permissible. In the Rodriguez case, I would submit that's very close to what happened here. In Rodriguez, they said that the day of the victim's family started off normally, but they didn't know it was going to turn into the family's worst nightmare. That is much what the defendant referenced when she referenced nightmare in this context. And I would say it's very different from Sanchez and Rivera, which are cited in the footnote of the Commonwealth's brief. And I would like to point out an error in my parenthetical with respect to the Rivera case, which is cited in my brief. That's the unpublished case. In that case, the court considered a claim of the closing argument in which the prosecutor stated that a sexual assault is, quote, every woman's worst nightmare. And the Commonwealth conceded, and Justice Wolohojian was on the panel in that case, and the Commonwealth conceded, and the court said properly that fell on the wrong side. Every woman's worst nightmare was obviously an attempt to identify and to play upon the fears of the jurors, and particularly the female jurors, in referencing sexual assault in general as, quote, every woman's worst nightmare. In that case, I made an error in the parenthetical when I said it was an objected to error. That's correct, but I said it was reviewed under substantial risk. That's obviously not correct. If it was preserved, it was reviewed under prejudicial error, and in that case, the court found, though it was error, the defendant did not suffer prejudice in the case, given the overwhelming evidence. And I would submit that that's similar here, even under the less favorable to the defendant, even more so under the less favorable standard that's applicable here, given the lack of any objection. I'd also point out something that, with respect to that nightmare reference, that I didn't well or clearly argue in my brief, which is obviously under the substantial risk standard, the defendant has to show error, he has to show prejudice, he has to show material influence on the verdict, and he has to show that this was not the failure to object was not a tactical decision. In the course of the closing or the defendant's case, they didn't expressly argue that the severity of the beating meant we can't trust what she says after the fact. But she did say that he did say that her inconsistent statements afterwards about where the beating occurred and her memory gaps mean we can't trust what she says about the identity of the perpetrator. It dovetails very nicely the Commonwealth's emphasis on the severity of the beating, which I would submit is not gratuitous, and I'll talk about that. For the defendant to say, to not object to the references in the evidence and to the references in the opening and closing of the severity of the beating, because it's very consistent with the defense theory. If the defendant was beaten so severely that we can't trust what she says about the identity of the perpetrator. And that is not gratuitous, both because SBI was charged in this case and because the Commonwealth's burden was to prove an unconsented touching, which was harmful and which had no justification or excuse. And if there are no further questions, I rest in my brief.
Let me just check. No, I don't see any. Thank you for your argument. Thank you both. It's an interesting case and we appreciate your argument in helping court in this format today because of the ongoing pandemic. But even though we're conducting it in this way, all the ordinary rules of our courtroom apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'm going to call the next case, which is Anne-Marie FOLINO-IANDOLI versus Kenneth LUCE, or LUCE, I'm not sure. Case number 2020P 0378. And with that, Mr. LUCE, would you please correct me as to the pronunciation of your name?
It's Mr. LUCE.
LUCE, I'm so sorry.
That's quite all right.
So with that, we're ready for you to begin your argument whenever you are.
Great, thank you. Good morning, Your Honors and members of the panel. I am Kenneth LUCE, representing myself as appellate in this case. I'm hoping that you're familiar with the briefs filed on my behalf. I am not a lawyer and could not afford one at the high expense. I'll do my best to be clear and explain my side accurately.
You should know, Mr. LUCE, I'm sorry to interrupt you. You should know that we will have read all of the materials that you have submitted. So you don't need to feel like you need to repeat or tell us what it was that you submitted in your briefs. We've read them.
Okay, great, thank you. The bottom line issue in this case is the significant gross disparity between both homes where the children reside and spend shared time. They both wish to continue this parenting schedule. Currently, I'm working in my own business, and we have the house where we've been living for 8 years. The issue is my grandmother had racked up immense bills when she was at the nursing home, and there was a lien on the home that I need to resolve with the state. That's kind of why we're here. I filed the complaint to modify and hopefully end the inconsistent child support and order so we can move forward with saving the home, the family home.
So there's a complaint pending in Barnstable?
I believe it's with the state. I'm not exactly positive. My mom is the overseer of the estate.
No, you said you filed a modification. Are you talking about child support or are you talking
Yes.
about the lien on the house?
The modification was filed in Barnstable, I'm sorry.
So that is pending right now in the probate and family court?
He had made a decision, and that's why we filed to be in front of you this morning.
Okay, so what you filed is in front of us now. There's not anything new in the probate court. I just want to be clear about that.
Nothing new. I'm sorry
Okay.
for confusion.
No, that's okay.
Nope, great. My first issue, the lower court, I believe, did not use the correct calculation method from the Massachusetts support guidelines. I asked them to consider using the shared calculation method. When I did the math and everything, it looked like mom was going to pay support of like $191 weekly based on our nearly 50-50 shared parenting schedule. I expected at least to get a hybrid because I'm over the excess of 33%, more in the 40s. The second issue, I guess, was the when he did make his decision to justify the deviation. I didn't have, I'm sorry. I didn't see which calculation method he was coming up with to order what I'm supposed to be paying.
So can I ask you, Ms. Luce, maybe this will help you.
Yep.
As I understand it, the guidelines, if the custody arrangement was 2/3 with mom, 1/3 with dad, would be that you would pay $229 a week to mom. And that if it was 50-50 parenting, and so the guidelines were run with each of you as custodial parent, and then the delta between those two orders would have been that mom would have paid you $191 a week. Is that your understanding?
It is.
And so what the judge did is deviated from both of those and came up with an order that you pay mom $100.
Correct.
Okay. And you say in your papers that you have the kids 47% of the time, is that right?
That is right, yes.
Okay. And that you asked for any adjustment to be retroactive to the date of filing of the complaint, correct?
That is also correct.
Okay. I don't see in the record, and maybe you could help me, what is the date that you served the mother with the complaint? Because that would be the operative date for any retroactive adjustment. Is that in the record?
Yes.
I believe it's attached to the brief, yes.
Okay. And then, is there
No,
a reason?
not the service of the brief, Mr. Luce. I think Justice Blake is asking you for service of the original modification complaint.
Yeah, I had attached that with it.
To the initial briefings.
Is there somebody, I'm hearing an echo, is there somebody next to you that's speaking?
No, there's nobody next to me.
Well, is there somebody that's, I'm hearing a woman's voice answering the questions.
It
And
could
so
be
I
in the
just want to
back.
make sure that it's just you, sir, okay?
It is just me.
Okay.
There is other people in the house, but
Okay, so where is the return of service, it's called, showing when the sheriff served your former wife?
I have that paperwork in the other room.
Did you put it as part of this case, if you know?
I'm not aware off the top of my head at this moment.
And the other thing that I don't see in the papers is the financial statements that you and your former wife filed at the time of these proceedings. Is there a reason that you didn't include those?
There's no reason, no.
Okay. All right, I'm sorry, you may continue with your argument. I just wanted to get those
Before we
questions.
get there, I have a couple questions. At the time you entered into the separation agreement, under which I understand you agreed to pay $149 a week in child support. What was the percentage of custodial time that you had and your wife had over the children?
At that time of the agreement,
Mm-hmm. What did you agree to under the agreement? How did that come out as a percentage of time for each of you?
I think that was pretty close to 50-50 as well. I think the reasoning that I agreed to that is because she had the children on her days in daycare.
Okay, so that there wasn't, so what is the, with respect to your request for modification, what was the change in circumstance that you were pointing to justify a modification of the amount that had been agreed to in the separation agreement?
Just the amount of years that have gone by. I'm working for myself now, where I was previously on unemployment, taking care of sick family members that are no longer with us. Just normal change of time, change of circumstances, and now that I need to save this house.
So that's one of the things that's tricky, right? Because you say in your complaint that there's been a change in your financial circumstances and you started your own business and you need clients to build up your business, but you did not include your financial statement, which would be not just your income, but your expenses and things like that in the record. Is there a challenge to how much money you earned? Did the judge question whether or not 822 was in fact your actual income?
No, I actually did a profit and loss for him, and there was no issues with it at all.
So
As
that
far as I'm concerned.
you told him you made 822 a week and he accepted that.
Correct.
And so how does the debt that you owe relative to your grandmother's lien, how does that impact you from a financial perspective? Because again, we don't have any of the financial documents here.
I apologize for that. Just trying to keep this house where the kids have been accustomed to for the last 8 years. Mom lives on the other side of town. Their grandparents are all close, so that it helps with schooling and everything else. I just want to get the house situated so we don't have any changes whatsoever and just in disruptions.
Do you owe the money personally?
I do not owe it personally, no. There's just a lien on the house. So I can't fix the house.
Whose name, what does the deed say as to who owns the home?
That would be Dorothea M. LUCE.
And is that your grandmother?
Correct.
And is she still with us?
She is not. She's passed.
What year did she pass?
Oh, boy.
Within the last 5 years?
Yeah, I think it's, I'm pretty sure. I'd have to look that up for you.
And so has her estate been settled in the probate court?
It has not, no.
So right now, who owns that home that you're living in?
I believe it would default to my mother.
And has your mother brought an action in the probate court relative to settling the estate?
I believe there's paperwork started. I'm not privy to that.
So did your grandmother pass before or after your divorce?
That'd be after.
Did your grandmother die before or after your complaint for modification?
Before?
Besides you and the kids, who else lives in that home?
I have my girlfriend of 8 years and her youngest.
And your mom does not?
No, my mom has her own house.
In the financial statements that you submitted to the judge, I guess they didn't, if I understand what you've told us so far, you would not have listed any obligation for the amounts owed for your grandmother's medical care because it's not a debt of yours. You're not on the hook for it. Is that correct?
Correct.
If we took the your grandmother's or her estate's liability for her medical care out of the equation, what would your argument be with respect, or do you have any argument with respect to the amount of child support that was awarded here, the $100 a week?
My argument would be without the house. The disparity between the 30%, 70% income, just trying to keep it even between the both. I mean, it's pretty lopsided in my eyes, and I'm just trying to follow the guidelines that the state has provided.
In your complaint for modification, in the section where you discuss the change of circumstance, you say that the modification would enable you to acquire a loan necessary to save his family's home. But as I understand it, and I just want to be sure about this point, you do not have a legal obligation relative to the family home. It's just that you feel there's a moral obligation.
That is correct.
Okay.
And the home is not, I mean, are you the beneficiary of the home once your grandmother's estate settles?
Maybe a small portion of it. I'd have to buy out the other remaining, my sister and my cousin.
You may continue. You still have a little over a minute left, a minute and a half left to go.
I'm sorry. Yeah, but I guess the third issue I guess I had was I don't know if it's actually, I would actually probably already even covered it. I guess one of the other things that they were trying to tell me is that I didn't make payments back in the day. I was making lump sums, and some of those lump sums were from my mom that I actually had to borrow. So there wasn't a gross time frame that I didn't not make payments. I mean, in the eyes of the DOR, yes, there is, but there was payments being made over the course of the
Well,
term.
does DOR think that you're current now, or do they still think you're in arrears?
Oh, I'm in arrears. I know that.
Okay. And you're paying those down at the rate of 25 a week?
Yes.
And are you current with that?
I've been current, yes, to the best of my ability. I mean, I might have missed a week here or a week there, but the biggest thing is the 50-50 schedule, the 30% to 70% of income being total between mom and I. That's basically the bottom line. I just would like to see where that deviation came from, or
Good. I think we understand your argument. We have your argument and we have your briefs. So now we'll hear from Attorney Henrique.
thank you for your time.
Good morning, members of the panel. May it please the court. Cases in family court bring moving pieces of human circumstances, and certainly many of them invoke empathy, and the trial judges at that level have to take into account so many parts of the human circumstance. However, what's before this court today is a judgment from October 2019 that entered a child support order. And I would suggest that the primary question, and certainly can address retroactive payments at some point further on, but I would suggest the main question before the court was there an abuse of discretion by the trial judge? And my suggestion is that there was not. There is certainly no evidence of clear error. He weighed relevant factors. He had been with the parties for almost 7 years from the date of the divorce, had presided over almost every hearing among the parties, including past modifications. And I think that it's some important language from Lapine, which I append in my supplemental addendum, is that these judges don't work with tabula rasa. And I do recognize, Justice Wolohojian, that you're very familiar with that case, and I think it's important language. I understand that in that case, it's used slightly differently, but I think it's important to recognize the importance of the jurisdiction that these judges keep for these cases, because they don't make these decisions in a vacuum. And I would suggest that this judge did not. He, in this final judgment, which is what is before the court, had 4 pages of written findings. He used several different calculations. He recognized that
they're not 4 pages of findings.
It's 3. I'm sorry. His final. Yes, I would.
His judgment is 4 pages long.
Yes,
they're actually not that many findings.
Okay, I do apologize. I wasn't trying to exaggerate that. I didn't mean judgment, yes. But he lays out where he was coming from. He acknowledges from the beginning of these hearings that it's not a 1/3, 2/3 situation, and it's not. I would suggest, though, that it's also not 47%. My understanding of the facts, and not that I can't be mistaken, is that father has the children on Monday and Tuesday nights, and then has them on Saturday and Sunday nights. The only change from the time of the parenting schedule, from the time of the divorce agreement to the current schedule, is that instead of having them on, and every other Saturday, Sunday night, instead of having them every other Friday, Saturday night, which was the case at the time of the divorce, he now has them every other Saturday, Sunday night. What this leaves us with a 28-day framework is 2 weeknights every week, that's 8 nights, and 2 weekend nights every other week, that's 4 nights. That gives us 12 out of 28 nights.
Perhaps you can help me. What I didn't see in the judge's analysis was any examination of the father's, well, maybe I'll start here. What do you, I'm assuming that the basis for modification was not the change in parenting schedule, but the change in financial circumstances of the father. And what I didn't see in the judge's analysis, and I'm not sure I can really find it in the record either, was some way to evaluate what that change was over time. We don't know what the father's wherewithal was at the time of the settlement agreement, or when the settlement agreement was approved, which I think is perhaps more important, where the judge can evaluate whether that amount of child support is appropriate, and how it's changed over time. Whether, this lien existed in both circumstances, although perhaps the lien is not, directly pertinent since the father has no personal liability on it. But I also don't see any analysis of the other side of the equation, which I think the other side of the equation also needs to be taken into account, which is the wife's means. There are allegations in the brief that the wife's circumstances have changed, and that she is financially in a better circumstance than she was at the time of the separation agreement. So what are we to do in the absence of the pieces of an analysis that at least customarily we would see in this kind of case? And without that, how do we know whether $100 is right or $100 is wrong, or within the zone of discretion?
What I would suggest is we do have record of past proceedings, which I do believe you are able to take in consideration, because again, the same judge has been able to take his past rulings into consideration, which is why I did include them in my appendix. So what I would turn to first is the 2014 consolidated judgment, where it is acknowledged that when the separation agreement turned into a judgment of divorce, that was actually a deviation upward agreed upon by father on father's behalf, $149, because at the time he claimed to be making, he was still, according to that judgment, he was still in the IT industry, but soon to be unemployed, and was making approximately $43 a week. Very, very little. Mother at the time of divorce, according to this consolidated judgment, was making approximately $1,100 from her primary job a week, plus $200 in supplemental income, essentially $1,300. The parties agreed upon $149 at that time of the divorce agreement, judgment of divorce. Certainly that from the beginning was a deviation. I think that's important to acknowledge. Then we move forward, and in 2013, 2014, we have the pleadings as to several modifications, contempt, and what we find there is that father now is on unemployment. He's making $325 plus $250 a month, which ends up being $132 a week from transitional assistance. That's when the trial judge attributes $600 per week to father for what he could make. Now, attribution of income, certainly its own argument, but I'd suggest that right now, it's not really an issue before the court, because even though he attributed $600 per week at that time, what we are left with the new judgment is, which is before the court, acknowledges father agreeing that he makes $822 a week. Mother has gone from $1,300 to $1,900 a week. So yes, she has increased, but so has father. And that's why
Is she still working 3 jobs? Because as I understood it, she was a special ed teacher. She had a part-time job on top of that, plus some self-employment income. So is the 1,900 just from her teaching?
The 1,900, I believe, is primarily from her teaching and a small amount from a very part-time seasonal waitressing job, which was acknowledged. I think that was about down to, it was less than $100 a week. And the self-employment piece is no longer, from my understanding.
Okay.
And that's what I think you can gather from what, again, the judge took into consideration when he was looking back at his past pleadings, which is important to realize that that's what he did between February and August. In February, it's clear from the record, and that is before the panel, that he hadn't looked at all the past decisions. Obviously, these are busy individuals on the bench each day, and it wasn't until the trial point that he, I think it's pretty clear from the transcripts, reviewed the whole history, and he had the whole picture again before him. And that's the whole picture that I think is the best record we have of where his thought process was.
So if you're not contesting the accuracy of these figures, that the father's income is $822 a week and the mother's income is $1,900 a week, can you help me understand the calculation of $100 a week in child support payment from the father to the mother?
Well, I think that comes down to the importance of the proper calculation of what the amount of parenting time is. And I know that I know father cites Davidson v. Davidson. It's acknowledged there. It's a very short Rule 128 decision where Justice Kinder, clearly you're more familiar with the background of that, but what it seems to me is that suggests right there in the footnotes that there really isn't a lot of case law out there as to how that calculation should be made. My findings, it looks like, again, just looking at another Rule 128, Petrangelo, that, and a couple others I found, that the courts are seeming to look at overnights. And if you do the calculation of overnight in this case, and if my calculations are correct, which I've run them several times, but we're all flawed, is a 43.57% balance. So if you were to take a traditional 1/3, 2/3, that's 33% versus 77%. The judge did is he ran let's stick with this first and then I can go back. So if you have a traditional 33.77, that's actually now 43.57. So father has the children 10% more time than he would in the traditional 1/3, 2/3 situation. The judge actually took the 149 and decreased it by 1/3. That's a pretty significant decrease for only a 10% increase in the parenting time. And he didn't just run the 1/3, 2/3. He ran what mother would owe under certain formulas. He ran what father would owe under the certain formulas. And I think he's very clear about that in his findings, which also, father does suggest that his situation is more like Davidson v. Davidson, but I don't think it is, because they really didn't know where the trial judge was at. Here, I think we do have a lot more information before us. He clearly has a history of these parties. He clearly does acknowledge that it is not a 1/3, 2/3, which is not clear in Davidson v. Davidson. And he has made written findings. I understand that they're not as extensive as perhaps the court would have liked, and might have made the decision a little bit easier on this court, but they are there and they do exist, and they do recognize the past history of these two parties.
Is there a reason you didn't include the financial statements in the supplemental appendix?
I was just going through my notes on that, and I think I thought that they were part of the record, and I apologize for that oversight.
Because under the child support guidelines, right, we don't count your client's second income, do we?
No, I would suggest no, but again, it being.
And then if Mr. Luce is a Schedule C employee, we would have a Schedule A to the 401 statement that would describe his income and expenses to see what Judge Riley had before him and what he credited and didn't credit. And none of that is before us.
And I do understand that, Justice Blake, that's not before you, but but the issue before the court, as I'm not so sure, it's what Mr. Luce is appealing is not the attribution of income of $822. That was not at question, and nor was my client's income. So I understand the importance of a complete record. I'm not trying to belittle that by any means. However, I do think what you have is essentially a stipulation of incomes. That's not what he's arguing. And today, honestly, what he's really putting forth his first foot before this court is this very difficult, again, human situation that if his circumstances were to change, if this home that has a lien is his primary residence and he were to lose that, all these things, absolutely, I would suggest could contribute to a material change of circumstances and could lead to a new complaint for modification. But that's not what this judge was considering. This judge was considering.
Are you saying that we basically should accept father's income $822, mother's income $1,900 per week, and the allocation of custodial time between the two parents, and on those two factors alone assess whether the judge abused his discretion in coming up with the $100 a week child support amount?
I think with the judge's calculations and looking at a 43 57% split, that yes, if you look at those calculations and you look at the percentage of parenting time, that you can come to the conclusion that there was no abuse of discretion. There was no clear error. This is not something that the judge just did willy-nilly. He thought about it. He had hearings, he heard argument, and he did give detailed calculations and his reasons why. So yes, I would ask the panel to affirm the judgment that was entered in October 2019 and base it on those numbers. I do think they are a rational, it is a rational way that the judge approached this case.
I think we understand your argument. Let me see if there are any questions from the other members of the panel. No? All right. Thank you both. It's an interesting case. We've been.
Okay, we are going live. We are on the record.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format in light of the ongoing pandemic. Although we are conducting court in this way, all the ordinary rules of argument as though we were in our physical courtroom apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Susan Pedro versus George Pedro, case number 220P0448. Attorney Nissenbaum, we're ready whenever you are.
Members of the panel, may it please the court, Wyckoff Nissenbaum on behalf of the appellant, Susan Pedro. The appellant has two principal main arguments in this case. One is that the separation agreement in this case includes language which states that each party waives any and all rights either party may have against the other under General Law 208, Section 48 to 55. And the alimony is calculated on gross income or gross taxable income. Therefore, General Law 208, Section 53C1, which states that income derived from assets divided pursuant to the divorce are not included in the alimony calculation, does not apply in this case. The other.
Can I ask you a question, Mr. Nissenbaum? A question about that. I'm looking at Exhibit B to the separation agreement, which provides an example of the calculation of income. And that example, as you know, says that the gross income is determined from salary, commission, and bonus for the calendar year. Why wouldn't it be reasonable for the judge to calculate based on that same example?
So my argument to that is that when looking at a contract, the first step in the contract is to determine whether the plain and ordinary language of that contract is clear. If that is clear, then then that should be binding on the parties. And the contract should be construed in accordance with that ordinary and usual sense. So it's my position that once the court determines that it is plain and unambiguous, there's no need to go look at by way of language or any other extrinsic evidence. If the court at that point believes that it's not clear, then the court should start looking at additional information in the language. If we look at that specific by way of language, it's not clear in itself. The language has two different terms for income. One says gross income, the other one says gross taxable income. I think there's also an argument that can be made that one includes just, look at the, it includes his base income, bonuses and commissions, but the other section doesn't include all three. So I would say in an ordinary sense, that statute definitely should apply, especially if the judge had issued a judgment. But here, where the parties were free to contract on their own and specifically included language indicating that 53C1 should not apply, and they were waiving those rights, I don't see how the
I thought that the purpose of providing an example would be to further explain what is meant by the term for which the example is provided. So if we use that definition, it seems to me what is meant by gross income is clear. Is there a reason we shouldn't consider the example?
Yes, because in this agreement, and if you look at the totality of the circumstances of the parties, this is a long-term marriage, 25 plus years. Mother was a stay-at-home housewife for the whole marriage. Father primarily worked. They raised these 3 children. And at the time of the divorce and as part of the agreement, there wasn't an unequal division of assets. Everything was divided equally. The amount of alimony pursuant to the guidelines could have been from 30 to 35%. Mother chose to take the base or the lowest possible amount. And she indicates that her intent was to do that was because she wanted to include all of his income. And his income isn't just base salary and bonuses. He also, as you'll see, he has significant, he has rental income. He was also outside it, so he was a mortgage broker, and he also provided private notes to clients or to outside of his main job. So there's nothing preventing him from shifting his income from working as a mortgage broker to shifting his income to now primarily from rental income to also receiving money from notes. So
I want to ask you a couple of questions, if I may. And part of it is to understand what is and is not at issue in the case. I take it that there's no issue before us, at least there's no argument made with respect to the second contempt complaint regarding the 529 accounts, correct?
Correct. That was not appealed by father.
There's no issue regarding the college costs, correct?
Correct. The judge ruled on that and that was not appealed.
And as I understand the judge's order is limited simply to rental income derived from a marital asset that was divided as part of the divorce. Am I correct on that too?
I don't believe that's accurate. I believe that if we look at his financial statement that was filed at the time of the divorce, that is in the volume 2 impounded appendix, We'll note that on that financial statement that's in there, there's two
I'm
property.
looking at paragraph 3 of the judgment.
Well, he indicates that any asset that was divided should not be included.
It says the court's determination applies strictly and only to the alleged income of the former husband derived from assets divided between the parties under Chapter 208, Section 34. I understand that to mean exactly what it says. And so your argument, I don't understand your argument about the risk of transferring, you know, income from one place to another and the potential harm that could accrue to the wife from that. Because here, as I understand it, the judge's order is limited only to an income derived from the assets divided as part of the, you know, the marital assets at the time of the divorce. Am I incorrect in that reading of the judge's judgment? I suppose that's a matter of law and we'll just decide.
So if that was just an order, I would.
It's a judgment.
It's a judgment. So the judge is effectively saying that the complaint for contempt that were filed, he's not in contempt, and that's the end of the case. He's not indicating that we can now go back and recalculate the numbers based on excluding assets divided, and we're just going to take into account his current income as well as income from assets that were not divided pursuant to
I'm not understanding that, what you just said. I don't understand what you just said.
So
Can you please
I
explain?
believe that the judge entering a judgment effectively ends the case for my client, and that she doesn't have the opportunity to argue, and she didn't have that opportunity to argue at a trial, that all of his income was not properly accounted for. At the pretrial, after a hearing, the judge said, I believe this statute applies and therefore he's not in contempt.
Right. So isn't your, what did your modification, what did your contempt complaint, what was your contempt complaint based on? I thought your contempt complaint was based on the failure to pay over 30% of the rental income from the asset that was divided as part of the marital property. Am I wrong about that?
It was from all sources. So our contempt was.
But I thought there was a concession that he had paid the 30% with respect to income from other sources. He made good on that eventually.
So eventually he paid 30% from W-2, what he claimed was W-2, but there was no additional payment from any other source. There was no argument over or agreement that he did pay. At the pretrial level, I argued that I wanted to know what the scope of our trial was going to be. And my argument was that if the judge found the language to be clear, then we didn't need to go into an argument over intent. But if he did not find the language to be clear, then we would spend time arguing over the intent.
Okay. If the language is not clear, how can the husband be held in contempt?
If the language is not clear, I think the court can go back, look at the intent of the parties at the time.
In order to construe it, but how can someone be held to have, what is the standard for being held in contempt?
Well, I recognize the court.
You need a clear and unambiguous
clear order and a clear violation.
Clear and unambiguous order. And if it's ambiguous, it seems to me by definition, you're going to lose on that piece.
But the court still has the ability, as I've outlined, to find an amount that is due. And the court also has the ability to interpret this agreement and indicate that X amount, certain income should be included, certain income shouldn't be included.
Is it your argument that you would have to take parole evidence on that and that you should have been granted an evidentiary hearing? Is that your argument?
That is one of my arguments.
So I'd like to ask you kind of a different question, which is looking at Judge McMahon's judgment, why do you say that this is a modification without findings? Why isn't it simply an explanation of why he found that the husband was not guilty of civil contempt?
Because he doesn't have, there was no material change in circumstances, my position, and that he just changed the agreement based on my original argument. So it all flows from the original argument that I do not believe that 53.
Well, there's a case from the early 70s, right? That I think it's called Blocksberg versus Blocksberg that says that you can modify on a contempt. So he had the ability to do it. You just suggest that he did so because he didn't base it on any written findings. I guess I'm having trouble understanding the interplay between if it's ambiguous, so you should have had a hearing, but if it's not ambiguous, you couldn't have modified it. I feel like I'm missing a link there. Can you help me understand? Are you arguing in the alternative?
Yes.
All right, so what's your primary argument? That it was unambiguous and he was guilty of civil contempt?
That's the primary argument, that it was unambiguous and the judge.
So then I would go back to Justice Kinder's first question, which is, what do we do with that example?
So the way I believe the example should be looked at is with extrinsic evidence, and to take into account not
so
just.
that goes to your fallback argument that it was ambiguous.
Correct. If it was ambiguous, then we can take that. If it's not ambiguous, I don't believe we should be looking at examples.
And then if we go back to Justice Wolohojian's question, on your complaint, were you suggesting that he had income from assets that were divided in the divorce and some that were not divided in the divorce? After acquired assets that generated income, was that your initial argument to Judge McMahon?
So yes, so originally he didn't pay alimony on his base income. He had withheld paying that because he believed she owed money for college. Eventually, after significant discovery, motions to quash, a lot of motion practice that we believe was unnecessary, he paid that money.
And did that income from which he cured come from an after acquired asset, or was that part of an income stream by virtue of a W-2 or a 1099 or something like that?
That was from his W-2. That was.
So what is the after acquired asset which generates income?
The rental properties and.
All of them?
No, so there were a total of 4 rental properties properties he listed on his financial statement in 2019, but there were only 2 that were listed in 2015. There's also only one of them overlaps. There's no clear, it's not clear where the monies came from and how they were paid for. That argument wasn't fleshed out at the trial.
Did you depose him on that?
No, we didn't have
Or do interrogatories? Okay.
It was our position that that money was, or those properties were not acquired from assets. They were acquired from earned income. And then we took a look, and I recognize the time expired. And I believe, so the appellee says it's de minimis. We believe it's not. On the financial statement itself, it lists $10,000 on his taxes financial. And then that also included depreciation, which isn't allowed typically by the court. So we're talking about around $20,000, we believe, in gross taxable income that should have been paid from alimony. So when the judge found him not in contempt on everything based off of 503C1, I believe that, at a minimum, he should have been found in contempt on the money he didn't pay off of the rental income as well as the income from the notes.
Okay, we're gonna have to leave it there.
Can I ask one follow-up? I'm sorry, Justice Wolohojian.
Of course.
If Judge McMahon had simply said not guilty, and there was no paragraph 2 or 3 to his judgment, about the income. Would you say that that was a modification?
No, I think if we had a trial, I would have filed a motion for findings. I would have understood where he was coming from. We would have been able to introduce evidence and he would have been able to hear everything.
Thank you.
I would
And
further,
you never filed a complaint for declaratory judgment seeking a judgment as to what the meaning of Exhibit B to the separation agreement is, correct?
correct.
Okay, we're just going to leave it there. Thank you very much. Attorney Kurhan?
Good afternoon. May it please the court, Dana Kurhan for George Pedro. Let me start off with the contempt issue. This agreement or this portion of the agreement could have been drafted better. It was not without ambiguity, and certainly it was not unambiguous in favor of the wife. So I don't think we have a clear disobedience, clear and convincing evidence of disobedience of a clear and unequivocal command.
But doesn't that then just jump off the page as requiring a remand so that the judge can take parole evidence as to this less than crystal clear exhibit to the separation agreement? Why don't you answer that, and then I'm going to ask you a follow-up about it.
Okay, so it's our position, now you look at what the agreement meant. And I think the judge did look at what the agreement meant. And I think it was clear to him, and it should be clear to this court, that the agreement meant that income as defined in the Exhibit B was salary, bonus, and commissions, and that's it.
So
yes.
if you look at Exhibit B, the thing that I just can't figure out, and I've looked at a bunch of separation agreements in my lifetime, this says that the parties are waiving past, present, and future alimony claims and the provisions of the ARA, but then agree to XYZ and talk about what could happen if the wife earned income and her reporting requirements. I'm struggling with the paragraph that says, is the initial opener, they're waiving past, present, and future alimony, and then they go on to describe what alimony will be and what may result in a modification, at least as to wife's income in the future. To me, that screams ambiguity.
Well, I think what they're saying is we're not adopting the statutory definitions of alimony.
Right, but they didn't say that.
Well, they said they kind of did, actually.
But what does waiver of past, present, albeit I'll go with that, and future alimony claims when he has an ongoing alimony obligation as of the day that this was executed and approved?
I think what they're saying is that whatever the statute says, we're not going to follow that, past, present, future, except that, here is our agreement. This is what we agree. This is how we define alimony.
And I'm honestly not trying to give you a hard time, Attorney Kurhan. I hope you don't feel that I am, but no. It then goes on to talk about when alimony will terminate, and it invokes two clauses from the ARA. So they want it both ways. They want to waive their rights to the ARA, but then they want to terminate it based on the ARA. So how do we square that?
I'm not sure if that's actually part of this appeal, but let me try to answer that.
But if we're trying to decide if the exhibit is ambiguous, right? Don't we have to look at the whole document?
I think we look at the whole document, but that's not where the ambiguity is. And I don't think it's much of an ambiguity. I think it's something that if we all sat down and said, what should we have put in there to make it clear that we're not going to consider divided alimony income based on divided assets, we could do a much better job. So it's not without ambiguity. However, as to what gross income includes, I think it's pretty clear what the parties intended, and what the parties intended were salary, commissions, bonus. Now, we can tell this because
What would be what is the difference in meaning between gross taxable income and gross income?
I'm not sure if there's much of a difference.
Well, how would we answer that question looking only to the contract?
I don't know.
Right,
I
so-
think
I don't know either. And I have another question for you. I read the judgment as being limited simply to rental income from properties divided at the time of the divorce. Is that how you read it too?
that's how I read it.
And if the complaint is not limited to that, what do we do with the remainder of the complaint?
Well, I mean, I think the complaint really is limited to that.
Well, it doesn't say that. The complaint says he hasn't paid 30% of income in excess of $175,000 a year. Doesn't tell us where that income's coming from.
what was discussed at the hearing was that he had not paid everything that he owed under the formula, which is salary, bonus, commissions. However, by the time of trial, he had paid that. And the only dispute is whether this, believe it was $13,000 a year in income from loans that he made and from real estate, of which he would get about $4,000. Is that part of the, should that have been paid also? So that's really what we're talking about. When you look at the 2015.
The judge doesn't look like, the judge didn't address that. Sort of set it to the side, if I understand paragraph 3 of the judgment.
The judge did say that. I mean, he essentially said, look, there's nothing owed. There's nothing further that is owed.
Where did the judge make that finding?
Paragraphs 2 and 3. The judge talked about assets for husband's income derived from assets equitably divided between the parties pursuant to that judgment. And it's our contention that the 3 properties that did not generate a lot of income, but they in 2019 they generated one or two of them generated some income. Those were equitably divided. Those are the same assets that were divided. That's my understanding.
About $200 a week after expenses? Is that
something like that? I think it was like a 188 or something like that. And not every year, but in 2019 there was some income. Now the parties did divide bank accounts, brokerage statements, brokerage accounts, things like that. And those, of course, are generating income. And that wasn't, nobody argued that should have been part of the husband's income or the wife's income.
Well, those are dividends and interest, right?
Well, there could be dividends and income. Income would be income. I'm sorry, interest would be income.
So then it goes back to Justice Wolohojian's question in my mind as what is the difference in this case between gross taxable income and gross income? And the IRS can speak for days about it, but what does it mean to the Pedros? And that's the piece I'm struggling with. And then you have a sua sponte order that just says I'm canceling the trial date. So we don't have a finding. I guess it's implied that it wasn't ambiguous, but everything that both of you have argued leans towards there was an ambiguity. And you say, Mr. Curhan, that even so it was resolved properly, but I don't know how we get there on this minimal record. And by that, I don't mean the documents you all put in, which were very helpful, but the judgment itself doesn't, he just says he's not guilty.
When you look at the hearing testimony, or not testimony, the hearing on this, the argument, it appears that the parties and the judge agreed that, well, we don't really need to have a trial to interpret this. This is what we have, this agreement. The agreement speaks for itself. Now, when I say it's ambiguous, I don't say it's ambiguous in the sense that we can't figure out what was intended. I'm saying that it was not ambiguous in that it is clear that the parties intended that income include salary, commissions, and bonuses. And that was all that was intended. And the parties.
If this is on a dismissal, there's no motion to dismiss, correct?
I don't believe there was a motion to dismiss.
Nonetheless, I think we review dismissal of a complaint de novo.
I think that's correct, but I think
we also, the interpretation of a contract is de novo, as well as the determination whether language, contractual language, is ambiguous or not. That's also a question of law.
I think that's a question of law.
So if we, as a matter of law, since we would be reviewing all this de novo, and if we look at this contract language and we determine that it's ambiguous, why wouldn't that just require a remand for everything that would normally flow from that, which is an evidentiary trial, or discovery and then summary judgment, something that would allow development of the facts on the question of the meaning of this ambiguous provision and the party's intent to the extent it bears on it?
Because I think the judge was entitled to look at this language and say, as this court is allowed to do, and say, look, what was intended was, here's our definition of income. And an example was given. And that example was the same. And then there was a discussion of, if the wife goes back to work, what happens? What do we consider?
The judge did that because what I see is the judge rested his decision on the legal view, a legal conclusion that if income derives from marital assets that were divided at the time of the divorce, then you don't pay alimony on that, regardless of the terms of whatever your contract is. That's what I understand the judge to have said. Nothing more than that. Limits his decision only to assets that were divided at the time of the divorce. I don't see the judge making an interpretation of the contract. I see the judge making a legal determination as to the effect of section 53C1 on this exhibit B.
I think the judge in paragraph 2 references the language of it says the language of the party's judgment regarding income. I think the judgment, of course, is the agreement. The parties came up with the agreement, and I think the judge is interpreting that language. The court accepted it at the time. It was the same judge. He accepted it at the time of the divorce. And I think, again, and he was, I do not believe anybody objected to canceling the evidentiary hearing. The judge said, essentially, I can figure this out. And I think he was right. When you look at the language of that, somebody probably should have put in a sentence or a paragraph saying, by the way, we're not going to consider any other income. We're not going to consider unearned income or passive income or anything like that. We are only considering salary, bonuses and commissions. That probably should have gone in there, but I think the judge was perfectly capable of saying that was really the intent of the parties. And I think this court can say exactly the same thing.
But if he had left his job, you wouldn't, and was solely self-employed, and it was a Schedule C DBA type of an tax situation, you wouldn't argue that that income would be precluded from consideration of alimony because the example didn't include the possibility that at some point he might be self-employed and had a Schedule C income.
Well, that would really be the same thing. That would be employment income. You know, I
How do
haven't.
we know that based on this language? That's where I get stuck.
Well, I suppose he could come back and say, you know, I'm no longer employed and or I'm no longer a salaried employee, and the wife would come back and say, yeah, well, he's doing the same thing just in a different form. You know, I have not had a salary and a paycheck since 1989, but that doesn't mean I don't have earned income.
Right,
So,
the earned income is not, the term used in this agreement is gross income.
And sometimes gross taxable income.
well, I mean, that's what it is defined. I think the parties anticipated that he would continue doing what he's doing. Now, maybe at some point in the future he won't, but at the moment that's what it is. I see my time is up. Unless there are any further questions, I'll leave the remaining points to the brief.
Let me check. Doesn't look like it. Thank you both. It's an interesting case, and we've been aided by your argument, so we appreciate that because of the ongoing pandemic. Although argument is being conducted in this way, the ordinary rules of argument apply just as though we were having court in our physical courtroom, and that includes that each side gets 15 minutes to argue with no rebuttal time. With that, I'll call the case of Lisa Hinckman versus Pride Chevrolet, case number 2020P0306. And Attorney Robertson, we are ready.
Yes, Your Honor.
We are ready whenever you are.
Thank you, Your Honor. Can everybody hear me?
Yes.
All right. This is a fairly straightforward appeal from the allowance of a motion to dismiss. The critical documents are at the record appendix 53 and 61 from the position of the appellants. Presents a straightforward issue about whether an insurance company can make gratuitous promises, in other words, false promises, in the words of the insurers' counsel, to its insureds. And our position is that insurers don't get to make gratuitous promises to the insureds. They don't get to break those written promises. Insureds do get to rely on the written promises of an insurer. In this case, the insurer broke a promise that was worth $4.45 million to the insureds in order to save $2 million on the settlement negotiations.
Can I ask you a question about about those figures? And sometimes,
yeah, sure.
Sometimes there's a little lag in time. So if you see us make a gesture, that might help know whether we're trying to get a question in. Can you tell me how you calculate this 4.45? Where does that come from?
Sure, Your Honor. The total set.
How do you do that math?
Sure. The total settlement in the case in settling the combined joint tortfeasors liability was 8.9. Since there were two joint tortfeasors as a matter of contribution law, it's a pro rata share. So your contribution claim is worth half if there's two. There's three, it would be a third. So you take half of 8.9, you get to 4.45.
The two tortfeasors being the driver.
That would be.
And the bar.
Yes, Mr. Ivano.
And the bar.
Yes, Your Honor.
And
yes, Your Honor.
You say they were each on the hook for how much?
They're each on the hook for half, according to Massachusetts contribution law. Law in Massachusetts says if you're in for 1%, then you owe what's called a pro rata share.
Okay, so
pro rata,
you're getting half of what? What's the gross number? The 9 point. What's the gross number?
The gross number is 8.9 million. 6.9 million was paid by the insurance company for the Ivanos. 2 million was paid by the insurance company for the bar.
Okay, so 2 million from the bar and 6.9 from the insurance company. You don't represent the bar or the insurance company. You represent the driver and the dealer, correct? The
I
driver,
represent the
the
estate of the driver,
yeah,
the estate of the driver and the dealer. They're really one entity for the purpose of this discussion.
okay.
And my brother, Mr. Dolan, who will speak second, represents the insurance company that
Right.
insured the driver.
So let's just call your clients collectively the insureds.
Yes, ma'am.
What did the insureds pay?
The insureds didn't pay anything. They shouldn't
Okay,
have paid
so
anything.
let's just stop right there. So they shouldn't pay anything. So how are they then entitled to contribution?
Well, under the Sword and Shield case, the contribution right arises at the time of the original accident. That's October.
It's an inchoate. It's under Sword and Shield. It's an inchoate right. It doesn't
Yes,
become an actionable right until something's paid. That's what Sword and Shield says.
Well, it's actually a little different than that, is my understanding. It's actionable in that it is pled commonly in the Commonwealth prior to any payment by anyone. It's often pled by the insurance company on behalf of the insured, and then it proceeds along, and then it's often resolved as part of the underlying case.
Any case that would support the proposition that under a theory of contribution, an insured is entitled to receive any damages where the insured has not actually paid out any money?
Yes, Your Honor. The Massachusetts law gives the contribution right to the insured. The insurer has no right to the contribution. It only has a subrogation right. So any payment on behalf of the insured is the money that's conveyed. Dealing with it any other way would be asking the insured to be contributing to the payment of an insured risk.
All right, so let's just take it, perhaps what I'm really struggling with here, and your question, and I hope you don't take this the wrong way. Your answers don't really help me.
I'm sorry, Your Honor.
Is the pragmatic reality of, I'm not talking about general principles of law, I'm talking about actual damages. Do you have any case where contribution was required or allowed in a case where the insured did not actually pay anything itself?
I don't, Your Honor.
So this would be the first case.
Yes, because the insurance company often pays, and this made whole doctrine, which is applicable here, doesn't arrive that often. That's why we raised it early with the insurance company and said the made whole doctrine prevents the insurance company from asking the insured to contribute, in this case, to give up some of what it could recover against the bar. And the insurance company actually agreed the made whole doctrine applied. And they put that in its RA 61. They noted that in discussion in that particular letter back to us, that when the insured has been made whole, so it was a recognition of three principles really here. One, the insurance company waived its right to subrogate. Secondly, the insurance company in writing said in its actual letters to us that if Zurich reaches a settlement of the case, Zurich will have Calitries released by plaintiffs in order to preserve the contribution claim. That's again at the record appendix 61. So there's been a waiver of the assertion of subrogation, and there's been a promise to preserve the contribution claim and recognition that under the made whole doctrine.
Mr. Robertson, can I come at this from a slightly different angle? Just as sort of a foundational question, is it accurate that at the foundation of all your claims is this theory that your clients lost a right for contribution based on misrepresentations that were made by their insurer?
Yes.
In other words, that's in all the claims that you bring, that is the source of the damages you are alleging, this loss of opportunity for contribution. Is that correct?
That would be true, Your Honor.
All right. On a slightly different topic, how do we factor into our analysis the fact that your clients independently settled with the bar for an amount that's not really clear from the pleadings, but I drew an inference that could have been $4 million.
I can tell you the amount of settlement was $750,000. And that settlement was of the wrongful death claims by the estate against the bar. That amount of damages is divisible and completely separate from the $4.45 million, which was the value of the contribution claim. As a practical matter or a pragmatic matter, the wrongful death claim was subject to comparative negligence on behalf of my insured's driving. Comparative negligence of Mr. Iavano wouldn't have factored into the litigation of the contribution claim. I would only need to prove 1% liability or negligence on behalf of the bar in order to recover 50% of the gross amount of proceeds that were received by the Hinman estate, the $8.9 million. So strategically, we wanted to bring the claim for wrongful death, which we had an economist to put the value at more than $5 million for the wrongful death claim, coincident and contemporaneous with the $4.5 million contribution claim. And together, we thought that would best maximize recovery of the $6 million, which was the coverage that the bar had. That's why we went through in great pains, as reflected in the record, raising the issue early for the insurer, committing the insurer to recognizing the made whole doctrine, then getting them to waive any claim to the contribution claim, and then getting them to actually pledge to preserve the contribution claim prior to going to the mediation. And preservation necessitates that there's settlement of the joint liability of both tortfeasors here, payment of what's called the common liability under the law. And then once you've paid the common liability, there's a complete ripening of this inchoate right.
So how do you respond, though, to footnote 12 of the judge's decision, where he discusses that would actually lead to a windfall, at least as to the Iavana party? What do you say about that?
Well, actually, under Massachusetts law, windfall to the person who's recovering is allowed. And you can get a windfall under, I think it's the Rubenstein case. And more to the point, the public policy here is that the bar, having overserved Mr. Iavana and caused the death of the breadwinner of two families and created two sets of children who don't have a father and two widows, should have appropriate allocation to the bar for its negligence of the accident here. So there's really no windfall to the Iavanos. What there is a recovery by the children and the widow for the negligence of the bar in overserving their husband and their father. It's not, I think characterizing it as windfall is wrong, and under Massachusetts law, it wouldn't matter.
I'm trying to understand something else.
Yes, Your Honor.
I take it that given the amount of the settlement of the wrongful death claim, that your argument is not, your claim as to damages is not that your own insurance company somehow diminished your ability to recover against the bar's insurer.
My claim is that my own insurance company, after promising that the contribution claim would be preserved and recovered by the widow Iavano, broke that promise, destroying the contribution claim.
That wasn't my question.
I'm sorry, Your Honor.
And your time is limited, so it helps if you actually try to answer the questions that are asked. My question was about, given the amount of the settlement of the wrongful death claim against the bar, your claim for damages is not that whatever your own insurer did reduced the amount available to you for your settlement of the wrongful death claim against the bar?
I believe the way your honors posed the question, I would answer it yes. My claim for damages is the lost contribution claim.
Okay, well, that helps me. And then the second question I have is your claim is brought, at least in this appeal, only against your own insurer, who did insure, cover all of its insured's costs, correct?
I would say that was incorrect. Our insurer saved itself $2 million, in effect taking $2 million. It saved itself $2 million by destroying the $4.5 or $4.45 million contribution claim. So it basically forced the widow Iavana to contribute to the settlement.
Is there any evidence in the record that that the estate of the driver contributed any money to the settlement?
No, and I would readily say that the estate of the driver didn't take money out of its pocket. As a practical matter of insurance law, it's not supposed to. It paid premiums. The premiums provided $15 million in coverage. There was $15 million to settle the case. And it would be an anathema to Massachusetts insurance law to require the insured, as a condition of the insurer settling the case, to take money out of its own pocket. And in this particular situation, we raised this issue where the insurer, having initiated the contribution claim, was putting itself in competition with the widow Iavana for the recovery against the bar. The insurer set this up. It didn't need to. It could have defended the case, not brought the contribution claim, let the widow bring the wrongful death claim, settle the case, discharge the bar, and then come to the widow Iavana and say, how do you want to resolve this where we're in competition under the made whole doctrine? They didn't.
All right, we have your argument. Thank you very much.
Thank you, Honor.
We'll now hear from Attorney Dolan.
Good afternoon. Thank you, Your Honor. May it please the court, Jeff Dolan on behalf of Universal Underwriters Insurance Company. We are requesting that the court affirm the trial court's dismissal of the third-party complaint against Universal because even if all of the factual allegations in that complaint are accepted as true, the appellant still had no right of recovery from Universal as a matter of law because the only damage theory that they've propounded here fails as a matter of law by Massachusetts statute. I'll skip right to the contribution issue because that seemed to be the most pressing issue. And that idea that Universal should have been obligated to settle claims against Calitres, the bar, which was undisputedly not an insured party under the Universal policy, for the purpose of preserving a contribution claim that never could have been actionable in favor of the appellants in the first place, fails to state a claim for two reasons. First is the lack of duty. Under Massachusetts law, you don't have a duty to settle claims on behalf of parties that aren't insured under your policy. But even setting aside the lack of a duty, that theory fails for the additional independent reason that according to the black letter statutory law, even if Calitres is named on a release, that contribution claim can never become actionable in favor of the insured appellants because Universal paid the entire settlement.
Let me interrupt with a question if I could. I've followed your argument thus far. What's a little bit unclear to me seems to be undisputed, and that is that your client, in fact, represented that it would settle with the bar with whom it had no professional relationship. It's hard for me to understand why such a representation was made in the first instance.
Yeah, and I think if you go back to actually to in the record appendix, page 61, the letter that's being referred to, and the language that was quoted by Attorney Robertson, where it says Zurich will have Calitres released by the plaintiffs in order to preserve the contribution claim. If you read the second paragraph of that letter, it very clearly says, in regards to the contribution claim, Zurich, which is Universal's parent company, Zurich reserves the right to recover under this claim if Mr. Iavana settles for less than the 6 million. And if such were to occur, Zurich would have the right to pursue a claim for contribution. So that letter actually in no way ever says that that claim now belongs to the insured or anything to that effect. It actually, what it says is that because this letter was sent before the settlement, Zurich would attempt to have that contribution claim, but of course, that course of action is contingent upon the plaintiff agreeing to that, the plaintiff not settling separately with Calitries. But to the extent that it was to preserve a contribution claim, it was to preserve a contribution claim in favor of Zurich as the insurance company, not in favor of the insured. So it's very clear in the writing. In the context that this came up in was that there had previously been a letter that's in the, or letters that are also in the appendix, to the effect that what had been requested of Zurich at that point was to not proceed on their contribution claims unless and until the appellant insureds were first able to access Calitries insurance proceeds, which is, when you read that record appendix 61 letter in context, what's being said is that we will preserve our contribution rights for ourselves, but we will not act on those contribution rights before the insureds are able to proceed on their own claims against Calitries. And not to deplete that $6 million, which Zurich / Universal never did. Zurich Universal, because the contribution claims were not preserved, did not actually obtain any of those settlement proceeds. So the short answer, I think, to your question, hopefully that was not too roundabout, is that I don't agree with the idea that Zurich ever did say we are giving these rights over to the insureds, and that even if you were to say that Zurich or Universal, I refer to the two interchangeably, even if they did waive any right or agree not to pursue that claim, that doesn't mean that that right vests in the appellant insureds. The appellant insureds only have an actionable contribution right under the terms of the contribution statute, which under section 1B requires that they pay more than their pro rata share. The statute very clearly says the right of contribution shall exist only in favor of a joint tortfeasor who has paid more than his pro rata share of the common liability. And then also under section 1D, I would presume in recognition of the fact that under a normal liability claim, there's insurance involved. So section 1D directly contemplates and addresses what happens in a circumstance where the claim is paid by insurance. And that very clearly is that it's the insurer that has that right of contribution to the extent that there's payment in excess of the pro rata share of the insured. So this is addressed. Sure, yes.
In this case, I take it then that in theory, the insurance company was in your view, was entitled to contribution from the bar's insurance company or from the bar.
Yeah, it would have been, and the way it would work is that Universal or Zurich has the ability, the statute refers to common liability. So they can settle on behalf of Calitries, which is their non-insured. And the benefit of doing that would be that they would have settled the common liability of the insureds and Calitries, and then they would subrogate to the right of the remainder of the pro rata share against Calitries. And so, but that was not how the settlement panned out, because the plaintiff lawyer elected to negotiate separately with the two parties. So where there was no release of common liability, there therefore was no contribution right.
Okay, so I take it then you don't argue with the general principle that underlies the driver and the dealerships or the insured's claim, which is the structure of this, the way these cases were settled, resulted in the loss of a contribution claim. But what you're saying is it doesn't really matter from the perspective of the insureds, because that contribution claim belonged to the insurer rather than the insureds, because it was the insurer who paid out the money.
Yeah, and I think maybe the helpful way, I'm sorry, I don't mean to cut you off.
No,
but
good to cut you off.
But I think maybe a helpful way to look at it is that there's been some discussion in the briefs about kind of this inchoate, unripe, not yet actionable type of a contribution claim, and then a claim that actually vests, and that claim can only vest and become actionable in a party that actually pays more than their pro rata share, whether it's the insured defendant or whether it's the insurance company. And the statute expressly contemplates what happens when it's either one of those. So if that right could never, as a matter of law, have ripened in favor of the insureds, because once we pay the whole thing, it can never ripen in favor of them, they weren't actually deprived of any actionable right of contribution. Because in order for them to be deprived of anything that's actionable, they would have to be the entity that pays more than their pro rata share. And they actually, as has been stipulated in the first argument here, they paid nothing. I don't think that's a disputed point, that we paid the entire amount of the settlement on behalf of the appellants in this case.
Was there ever an argument? Was there an argument made on behalf of the insurer before the motion judge that as a result of what you just summarized, the insureds didn't even have standing to bring this claim?
I don't think it wasn't argued as a standing issue in the underlying case. I think maybe standing's implicit in the idea that they never had a ripe claim. But I think our argument was more directly under the statute that you would only have a ripe claim of contribution, that under the theory that is articulated in the complaint against Universal, if that's their theory of damages, and they cannot have been damaged in that way as a matter of law, our argument was a lack of damages more than a lack of standing, but the standing is kind of implicit in there, that if they don't have an actionable claim, that they don't, then they never would have had standing to pursue any contribution claim against anybody else. And this was also kind of touched upon in Attorney Robertson's oral argument and some of the questions, but we raised this issue, and it is referenced in a footnote in the trial court's opinion, that the unreasonable precedent that would really be set here to allow the appellant's theory that when they pay out no money and an insurance company settles a claim on their behalf, that they would be entitled to pursue 50% of that amount that is paid on their behalf, kind of as an offensive weapon in their own case for their own damages against Calitries. I think that's wrong for a couple of reasons. Is that, number one, it's directly contradictory to Section 1D of the contribution statute, which expressly contemplates what happens when an insurer pays. It's expressly contradictory to paragraph 1B, which says that no party has an actionable claim unless they pay more than their pro rata share. But it just fundamentally, the fact that a contribution claim is a derivative claim as a method of allocating common damages caused by joint tortfeasors, the statute also says that it has to be for the same damages to the same person. So it's not a separate claim that you can use as a sword in your own wrongful death action that relate to your own damages. It's only a derivative claim that dictates how the damages are allocated among jointly liable parties for the same damages. So if the court were to accept this analysis, the precedent really would be that any defendant insured in any case would arbitrarily be entitled to recover 50% of the amount that an insurance company pays to settle claims against them, even if that insured doesn't pay anything. And I would posit that while it may not be a per se ban on windfalls in all cases, that would establish that the contribution statute entitles a defendant insured to a windfall as a matter of law. I think that's clearly contrary to any real rational public policy considerations, especially in the case of a high-speed wrongful death drunk driving accident. But as I've said a few times, more importantly, the court, in order to accept that analysis from the appellant, it would have to ignore the express language of Chapter 231B, and the court can't ignore what is the plain language of the statute in accordance with the legislature. I've referenced previously, it came up pretty quickly. I think we've expressly stipulated in the opening that there's no claim for damages here because of a loss of Calitri's insurance proceeds. Even after their insurer paid out $2 million to settle the Hinman estates claims, there would still be $4 million left if the settlement was $750,000 by my math. That leaves about $3.75 million that were not even paid. So there's no claim here that they were unable to collect on that judgment as a result of any deprivation of insurance proceeds, much less the fact that Universal had no duty to settle on behalf of Calitri's or to preserve those claims.
And why does the holding of Sword and Shield not apply to this case?
I think very straightforward that all that Sword and Shield said was that inchoate right could be included in the terms of a general release, that it's a claim that exists in the ether, but it's not yet actionable. And as I said, if their theory of damages is that they were deprived of a contribution claim as a result of the conduct of Universal, in order for that to be actionable, it would have had to actually be an actionable underlying contribution claim. Otherwise, they have not actually lost anything. So all that case said was that it can exist in an inchoate form such that it can be subject to a release. It doesn't talk about any of the direct issues that we actually talk about in this case or that arise in the briefs. We're not disputing that it can exist in an inchoate form, but the point is that they can't be damaged unless they lost something that was actually actionable, which it couldn't be for the reasons that I've stated. A few miscellaneous doctrines that I just very quick, I know I'm running a little bit low on time, that I just wanted to quickly address is that in the briefs, there's some reference to case law, and it's actually the Rubenstein case that was addressed in the Attorney Robertson's oral argument about the enforceability of assignments under Massachusetts law. Those cases are completely irrelevant. There's no assignment to enforce. That's very clear at Record Appendix, page 187. The appellants have said not just that the claim was never assigned, their position has been it was never assignable as a matter of law from Universal to them. So there's no assignment at issue. The idea of whether they're enforceable is irrelevant when there's no assignment to enforce. The doctrine of waiver comes up a few times. I think I mentioned this earlier, but just to drive home this point, that even if you accept the allegation that Universal waived a right of contribution for purposes of a motion to dismiss, I think we certainly have different views of what actually happened in this case. But even if you accept that for purposes of a motion to dismiss, that doesn't mean that a claim vested in the appellants. So if Universal elects not to proceed on their contribution rights, that does not mean that the appellants paid more than their pro rata share, and it doesn't mean that any of the circumstances contemplated in the contribution statute under which such a claim can vest ever actually existed. So the idea of waiver or assignment, they have no relevance to this case from our perspective because they don't establish that any actionable right of contribution could ever have existed in favor of the appellants. There's also the Kiribati Seafood versus Deschert case. I have about 20 seconds, but we addressed this case pretty substantively in our brief, but that case has nothing to do with anything that's relevant to this case. The only reasons that doctrines like subrogation or assignment even were mentioned, that was a legal malpractice case that addressed a causation standard. The underlying case involved an assignment, but it was litigated under French law in a Tahitian court. The SJC had no analysis of these. So I recognize I'm out of time. So unless there are any other questions for the reasons I've stated, I would just respectfully request that the decision be affirmed.
Let me check. Thank you both for your arguments. It's a very interesting case. We were helped by your arguments on both sides.